Chapter 12, Landlords and Tenants. This is going to be a long chapter because it includes everything we've gone over as far as ownership. We went over different chapters that covered different issues pertaining to ownership. This chapter has everything pertaining to rentals in it. Types of estates and land and all that stuff. So in this chapter, Landlords and Tenants, we're going to explain characteristics of the four types of leasehold estates. We're going to describe the standard lease provisions, including various forms of eviction, learning what eviction is, and the effects of the Truth in Renting and the Americans with Disabilities Act. Some of it we've gone over before in chapter 4. Discuss differences between various types of leases and identify what is the primary function of a property manager and who acts as a property manager and all that jazz. So let's start off with a lease. What is a lease? A lease is an intangible asset that's considered personal property because you don't own real estate. It's personal property. There's only two kinds of property in this world, either real or personal. And because you don't own it, then it makes it personal. And it's an intangible asset because it symbolizes your rights to occupy someone else's property for a limited period of time as defined in that lease. Now, the owner is known as the lessor. They're the one who intentionally transfers most of their rights as well as the possession of their property to a tenant who is the lessee for a limited period of time as defined in the lease. So the lease sets forth the length of the contract, the amount that's to be paid for the right to use the property, and it defines the rights and obligations of each of the parties. Every lease has a demising clause in it. Its demise is a transfer of property by lease. So every lease has a demising clause in it describing what exactly the landlord is renting and that the tenant is taking to take possession. So, in that regard, a lease is both a contract as well as a conveyance of the real property. So, let's do the highlights right now.
Where is that?
This is page 227 and 228.
Oh, there it is. A lease. I see. A lease. An owner of real estate. Right of possession of use for the owner intended for a specific period of time.
Mm-hmm.
Okay, and then transfer of property by lease is known as a demise. Got it. Okay. Next page, New Jersey statute of frauds.
Okay, so you guys got those?
New Jersey statute. In 1 second, this what that say? New Jersey statute of fraud requires that a lease for a period of more than 3 years be in writing. Got it.
And that it could be recorded if it's two or more. Now, that does not apply to leases we do because every lease we do does not matter the length of the time. The leases that we prepare always need to be in writing. Doesn't matter how long it is.
Okay.
This is just the statute of frauds dealing directly between the owner of the property and a tenant. Well, if they have no real estate agent involved, the leases must be in writing if a period of more than 3 years. All right. So, statute of frauds, there we go. Here's that slide again. Contracts for real estate must always be in writing. Contracts for the sale of real estate must always be in writing. Leases, they only need to be in writing if they're 3 or more years, but if a licensee is involved, doesn't matter the length of time, it always needs to be in writing. Leases can be recorded if they're 2 or more years so that they can record that long-term interest in someone's property. Okay. Because we can agree that it's extremely risky to rely on verbal contracts for agreements for the leases Uh, how do you prove what was actually gone over, what the agreed upon terms were, and everything after the fact? It's always wise to get it in writing, even when you're not using a real estate agent. And we follow licensing law, the administrative code. These things tell us that we always have to have our contracts that we prepare in writing. So, an estate and land describes the amount and kind of interest one has in real property. Chapter 6, we went over the three types of freehold estates. Anybody recall what they were?
Yes.
The first one is goes
Fee
by three
simple.
names. Yep. What is fee simple also known as?
Fee simple. Fee absolute.
And just fee.
And fee.
So it's fee simple, or fee simple absolute. Then the next one,
Fee determinable.
also known as
Uh,
defeasible or
Defeasible.
conditional
Conditional, yeah.
fee estate, because it's based on a
And
condition.
and life
And the
estate.
last one is a life estate, correct.
Mm.
And what do we call a life estate that's based on someone else's life, a third party's life?
Parotravi.
For otra vie, there you go. It means for the life of another. Okay, so in this chapter, we're going to be going over the four types of leasehold estates. Leaseholds are less than freehold. You're not free to hold the property forever or a lifetime, but uh, we're going to go over what exactly these temporary leaseholds estates are. So leases are not ownership. So the leasehold estates are not an ownership category of estates and land. Let's see. An owner intentionally transfers some of their rights to the tenant for a period of time, as defined in the lease. So the lease is considered to be personal property because it symbolizes your rights to occupy someone else's property, and you can't touch a right, so therefore it's intangible or incorporeal assets. So here are the four types of leasehold estates we're going to go over. An estate for years, which need not be for years, so don't let the name fool you. Lease estates for years could be for a month, 3 months, 6 months, a year, 2 years. So don't let the name fool you. The distinguishing category, the distinguishing feature of an estate for years is that it has a start date and an end date. You know when an estate's going to end. You have a periodic estate, also known as period to period. Um, this one, instead of having an end date in it, it has an automatic renewal date. Unless somebody gives their notice to quit, this type of leasehold will automatically renew for the same amount of time it was originally written for. Then we have an estate in tenancy at will. Okay, at will. So this is, as long as the parties want to be in the leasehold estate with each other, they can at will. But either party has to give 3 months' notice to terminate. And an estate or tenancy at sufferance, well, we'll go over this one, but an estate or tenancy at sufferance is somebody who once had a valid lease. The lease term expired, they did not renew it, um, and they didn't move out, and they're not paying rent. So every day they remain, they cause the landlord to suffer. Thus the name tenancy at sufferance. All right. So we're going to be going over these three. Now, rent is due at specific intervals per the lease. If it's not stated in the lease, New Jersey state law actually says that rent is due in the arrears at the end of a term for which you occupied the property, the opposite of in advance. We all know that I say, when's the rent due? You're like the first of the month, right? But if it's not specified in the lease, according to New Jersey law, it's due in the arrears at the end of the month. So anyone who terminates a lease early is in breach of contract, because it is a contract. A holdover tenant is a tenant who did not vacate the premises after their lease term rights had expired. Um, it's not necessarily a negative thing. They could be there and paying rent, and the landlord accepted them. That's fine. Um, So they could either accept the holdover tenancy or they could evict them because they didn't sign a new lease. Now, what is eviction? See, I got a bunch of definitions and terms here we're getting to a little bit early because I think that we should understand these before we get into each of the specific lease terms, types of estates. So I think it's important to know these things, so I put them up front here. So an eviction is the legal process of removing a tenant through the court system. A landlord cannot lock out a tenant or turn off their services or physically remove them. Tenants have rights, and New Jersey is a tenant rights state where they really favor the tenants more so than landlords. So evictions the process of revoking the rights that were granted to the tenants because the tenant violated the terms in the lease that granted them those rights to begin with. You know, remember, when somebody's got rights, you can't take them from them. But if they violate the terms which granted them those rights, uh, like with a lease, they can be revoked, but not by the landlord, by the court. It still must be done by the court. So the landlord can't just go in there, change the locks, throw your crap out at the curb, and say, adios. Your rights need to be taken by showing that you violated the terms of the lease somehow. Whether it's you didn't renew the lease and sign a new lease, so then you have no right to be there, you're not paying rent, or some other terms of the lease that have been violated. The landlord could take you to court to get you evicted because they're just revoking your rights to occupy the property and any other rights that they were granted to you in the lease, which you have violated the terms of somehow. The main way that most people do it is by simply not paying the rent. We're going to go over a bunch of different types of ways people violate the lease. And if it's for any reason other than non-payment of rent, the tenant or the landlord needs to notify the tenant in advance that they're violating the lease terms before they could file for eviction. They could give them, serve the tenant with a notice that they're violating the terms and to get their act together by a certain date. Otherwise, eviction will happen. And depending on what it's for, will dictate how much notice the landlord needs to give the tenant or how many times they need to give notice to the tenant. We don't need to study that guide at all. The only thing we're going to need to know from that guide is that what's the only reason that a landlord can evict a tenant without supplying them any notice in advance, notice to quit in advance, and it's non-payment of rent. So there are 4 types of leasehold estates. There we go. That's why I wrote the number 4 in front of that. And then I just highlighted them down. Estate for years, periodic estate, tenancy at will, and tenancy at sufferance. So there are 4. What are the distinguishing characteristics of each one of these estates? Let's highlight distinguishing characteristics of a leasehold estate. And the first one, estate for years, is for a definite period of time. Right next to that, for a fixed term with an end date. For a fixed term with an end date. You're writing that next to estate for years, where it says its distinguishing characteristic is that it's for a definite period of time, right? For a fixed term with an end date. When it expires, you know you got to go unless you signed a new lease. Now, a periodic estate from period to period automatically renews. So right next to that has a renewal date in it. It does have a date in it, but that date is a renewal date.
So, for estate for years, it's a fixed term with an end date. It can be for 1 year, 2 year,
6
2
months, a month.
months, 3 months.
Yep.
Okay. And
It doesn't
renewal
have to
date
be
is
3
like
years. Yeah.
similarly with renewal date, but with not a fixed term.
I'm sorry, you're talking about the estate for years still?
Yeah, no. So fixed term, I got it that it has end date
Okay.
and starting and end date. like for
Uh-huh.
year, months, or whatever.
Yeah,
And then period to period is also the same. It can be for 1 year, 6 months, 3 months, 2 months, but
correct.
it
But
will keep renewing itself.
correct. It'll automatically renew if the tenant does not serve their notice to quit, that they don't want to renew it.
Okay.
Now, how much notice do they need to give the landlord? It depends on the term of the lease. Week to week, 1 week's notice. Month to month, 1 month's notice. If it's for a period of years, 3 months' notice is needed. Otherwise, it'll automatically renew for the same amount of time that the lease was originally written for. And an estate at will is for an indefinite period of time. I want you to associate the, the word indefinite with estate at will. I don't want you to associate it with a periodic estate. It makes sense, the definition they give in the book, but I'm going to show you when it comes to the definition for periodic estate, we're going to cross out the word indefinite because I don't want you to associate it with an estate at will. Even though it makes sense how they wrote it, they give you questions on exam, which type of estate is for an indefinite period. So I don't want you associating the word indefinite with a periodic estate, even though it's not defined because technically it keeps renewing, so it's not defined in that regards. And an estate at sufferance is without the landlord's consent. You know, you're not even supposed to be there. Okay, let me know when everybody got that written down and those highlights done so I could change the slide.
Done.
Okay.
So at
Yeah.
tenancy at will, it's not renewed. I mean, is it for lifetime or
Uh, there's no
indefinite?
stated length of the term. It's
Okay.
at
You
will.
could,
You could
some
stay
people
there as
don't
long
renew
as
it.
you want at your will, but you need to give 3 months notice before you quit, before you move
Okay.
out.
3 months here also. Okay.
Yeah.
Thanks.
Okay. Now this is usually used for specific reasons, like if a property is going to be taken by eminent domain. The landlord doesn't know when the state's going to come in and take the property. So in the meantime, what do? They can't write a new tenant a year lease because it may be less than that. They may not have it for a year. So it'll be a tenancy at will. It's an agreement between both the landlord and the tenant that they both understand that either one of them has to give 3 months notice to terminate the estate. So you could come, you can move in, you could stay as long as you like, but just know, state at some point is going to notify me they're taking the property by eminent domain, and whenever that happens, where they're giving me an actual date that I need to be out by, they'll give me at least 3 months notice, and I'll let you know, give you your 3 months notice, okay, as a tenant. So that's where it would usually be used in situations like that. So, once again, here's my definitions for them. Estate for years is a lease for a definite period of time for a fixed term, has an end date in it. Periodic estate, lease with a stated term. That term automatically renews. So instead of an expiration date in the agreement, it has a renewal date in it. The lease would automatically renew for the same amount of time the original lease was written for. And a estate or tenancy at wills for an indefinite, undefined period of time. So, and a tenancy at sufferance is without the landlord's consent. Okay. So, once again, each one of them, let's do the highlights now for each one of them one at a time. Estate for years. Okay. It could be for a fixed term, but it doesn't have to be for a period of years. So don't let the name fool you. Could be for a week, 3 months, a year, 2 years, etc. Specific defined period of time with an end date in the term. And no notice to quit is required to terminate at the end of the lease because it automatically ends if you do not renew it and sign a new lease. Because it has an expiration date in the lease, if the tenant doesn't renew by signing a new lease, they have to vacate by that date. Okay. So no further notice is needed from the landlord to tell you to get out. You know when you got to get out. The lease expires. So let's do all that highlighting that says that as well. Okay. Everybody good? Okie.
Yes.
So periodic estate lease with a renewal date rather than an expiration date. It automatically renews for the same amount of time the original lease was written for, unless either party gives notice to quit, to terminate before the renewal of the lease. Now, how much notice is needed? Well, this slide I have everything you need to know. Week to week, 1 week's notice; month to month, 1 month's notice; period of years, 3 months' notice. So when a tenant gives their notice to quit, but if they don't vacate, they can be held liable for double the rent for each month that they've held over.
Ooh.
So you can't tell a landlord I'm moving out and then not move out, because the landlord may have arranged to get another tenant in there. And now the landlord's in breach of contract with the new tenant because you didn't move out yet. So they could charge you double the rent to cover the other tenant's costs to be somewhere, perhaps. You follow? So that's the rationale behind it. So let's do these highlights and cross out the word indefinite under periodic estate. It'll still make sense. Okay. Just going off screen for a few while I eat my breakfast while you guys take notes.
I have a question in mind. So, when the tenant occupies the property after the stated ending date, it creates a holdover tenancy. But here, in this periodic state, it renews it by itself. Then, how it is? Okay, okay, got it.
Again, figure it out yourself, I guess, huh? Okay.
They gotta pay, right, for the time that they're there if they're late. So I guess the pressure is nobody wants to pay double when they want to get out, so they'll meet their exit date, right? Is that the answer?
Wait, I'm sorry. Can you repeat that?
It's okay. I got it. I was just talking out loud.
Oh, okay. All right. So everybody got the highlights now? We're good?
Mm-hmm.
All right. So an estate or tenancy at will, it's for an indefinite, once again, undefined period of time. Um, Either party has to give 3 months notice to terminate it. Termination is automatic upon the death of either party. So if you need to finish, if you need to get out of the term a little bit earlier, don't go killing nobody. All right. The joke is a joke there. All right. Both parties have to agree to that 3 months to terminate. And this is, once again, I put a little explanation here when it's often used. It's often used when somebody's notified their property is going to be taken by eminent domain. Hey, the landlord still got to pay their taxes. They still got to pay a mortgage on the property. So they could still rent it out, but you can't give these long rental terms because you may have to deliver it vacant to the state at some point. So a tenancy at will would be the best option. So the landlord doesn't have to worry about being in breach of contract with the tenant when the state notifies them, hey, you need to deliver a property vacant to us ASAP. You know, this is the way to get them out by having an agreement and the 3 month term. And it's fair to everybody that way. Okay. Got all the highlights? It's only two sentences to highlight there. Okay. And then an estate or tenancy at sufferance. Tenant who had a valid lease, the lease expired. Tenant didn't renew it, and they didn't move out. Now that makes them a holdover tenant. But in addition to that, they're also not paying rent. That makes them a tenant at sufferance. So a holdover tenant that's not paying rent can be evicted at any time for the non-payment of rent. No notice is needed to start the eviction process, and they're not they don't have squatters' rights, which could create an easement by prescription. This tenant once had a permission to be there. Okay, remember you can't claim a easement by prescription if you have permission from the landlord. Okay, so but now they're there and their lease expires. The landlord should take action to get them removed, eviction. Okay, because they didn't sign a new lease and they're not paying rent. So just as fee simple absolute is the highest estate in the land, unrestricted ownership forever, tenancy at sufferance is the lowest. Think about it. The tenant's rights expired. They have no right to be there anymore. They didn't move out and they're not paying rent. So the tenant can be removed at any time. So the tenant's rights expired, didn't move out. Tenants aren't paying rent. For every month they remain, the landlord is suffering. They still need to pay their bills. So that's where they get that term from. So it's make sure that when you highlight the definition here in the book on page 229, you also write up there they're also not paying rent. That's an important factor that they left out in the book here.
So, in periodic state, when the lease renews by itself and they do not pay the rent, holdover tenant do not pay the rent, then it is tenancy at sufferance, right?
Correct.
Thanks.
Correct. If they're not paying their rent. Well, if they're wait, tenancy at sufferance is if the lease term expired. They or they like tenancy is
So the holdover tenant is the part of periodic estate, right? When it automatically renews, it's a holdover tenancy.
no,
So
because
okay,
it automatically renews. That means that they have a lease right to be there. But if they're not paying rent,
then it
any ten,
is.
any tenant can be evicted at any time that's not paying rent. You're not a tenant at you don't have a tenancy at sufferance because you have a valid lease. Tenancy at sufferance is one who does not have a valid lease anymore and they're not paying.
Got it.
It's a little different than somebody who has a valid lease but they're not paying
Okay.
rent. Okay.
Okay.
Okay. So to recap, demise is a transfer of property by lease. Don't confuse it with devise, which is what's
Um,
devise?
device is mm, the
Ownership, like mortgage.
transfer by will.
A transfer of property by will
By
upon
will.
death.
Yeah,
Correct. Upon death. So demise is the one that sounds like death, but is not. Devise is the one that's by transfer of property by death. Demise is transfer of property by lease. Leasehold estate is a tenant's rights to occupy someone else's land for a period of time. It's considered personal property, which is an intangible asset. A holdover tenant is a tenant whose rights to occupy real estate expired, but did not vacate at the end of the term. That's a holdover tenant, whether they're paying rent or not. That's what a holdover tenant's defined as. And there's four types of leasehold estates: estate for years, which need not be for years. It could be for a month, 3 months, 6 months, a year, or it could be for years. Its distinguishing characteristic is that it's for a fixed term, has a start date, has an end date. So you know when it ends. You got to be out by then or sign a new lease, one or the other. Periodic estates, so no further notice is required from the landlord to terminate an estate for years. It has a termination date in it. If you don't renew it, you got to be out by that date. Periodic estate, on the other hand, it automatically renews. So one of the parties needs to give notice to terminate, to quit. Otherwise, it will automatically renew for the same amount of time it was written for. How much notice is required? Well, it depends on the lease term. If it was for a week, 1 week, month, 1 month, period of years, 3 months notice. Tenancy at wills for an indefinite, undefined period of time. You could stay there at will, but either party must give 3 months notice to terminate. And a tenancy at sufferance is one who had a valid lease. The lease expired, they didn't renew it, they aren't paying rent, and they didn't move out. So every day they're there, the tenant is causing the landlord to suffer. Thus, the tenancy at sufferance. Okay. And tenant at sufferance can be evicted at any time because they don't have a valid lease, number one. And number two, they're not paying rent. And you're living in someone else's place. Okay. So here's some standard provisions that are put in leases. You know, just like any contract, parties got to have capacity to the contract. We need competent parties. There has to be a demising clause that says the landlord is to lease the premises and the tenant is to take possession. The description of the premises, what exactly is being rented and what is excluded from the tenant's use. That's important because if you don't put what's excluded from the tenant's use, the tenant has the right to use the entire property. You know, sometimes landlords rent a house and they may say, well, the garage is off limits because I got my tools and my car in there and stuff. Or, you know, you got half of the attic or half of the basement, you know. Well, they need to specify that in the lease. Now, the term must be clearly stated, the duration, or if it's at will or automatically going to renew. How and when the rent to be paid must be specified, because if you don't, New Jersey law says that the rent is due in the arrears at the end of the term, the opposite of an advance. And leases must be in writing for a term of more than 3 years, and they can be recorded if more than 2. But they always need to be in writing if we're involved. Licensees are involved, right? And signatures. Lease is not valid unless everybody signed it. So it's important. Listen, sometimes landlords play games. I've had this where you got the tenant that signs a lease and submits it over to the landlord, and the landlord never gives back the signed the lease with their signature on it. So I guess this way they have a fully executed lease in their possession, but then the tenant doesn't. Our job is to make sure that both parties get a fully executed copy, right? It's important for a tenant to have that. All right. Window guards. Anybody ever hear of those things? Well, you're on page 235, section 36 of the contract. Put a highlighted box around section 36, talks about window guards. There's no paragraph in this book that explains what window guards are. There should be, but there is not.
Wait a minute, what page is this?
235, section 36 of the contract.
235.
Yeah, section number 36. I'm not going to go by these line numbers because they may be different in the current book.
235. Okay, what are we talking about? Window guard notification.
Yep.
No, that's not even the same. Oh, there we go, right there.
All right. Just put a highlighted box around the entire section 36.
Okay.
Now, I got explanations on slides here, so I'm going to change the slide. Here's what you need to know about window guards that are in the box up the top. The rest is additional information for your own edification about window guards and other types of properties. What are window guards? Well, window guards prevent the window from opening wide enough for a child to fall out. They actually prevent the window from opening more than 4 inches. This applies to buildings with two or less rental units. Okay. Um, Window guards must be installed by the landlord if a child 10 years of age or younger will be living there or regularly present. If the tenant gives the landlord a written request to install those window guards, homeowners associations are responsible for installing them in hallways and common areas, of course. And window guards are only required on first floor units if the window sill is at least 6 feet above grade, above the ground. That's what that means. The window sill is the bottom of the window. So if the bottom of the window is at least 6 feet above the ground, that child falls out, they can get hurt. So they need to have a window guard. Higher levels or elevations, well, if there is a condition present that could be dangerous, then window guards could be installed. Of course, higher elevations that could apply as well. But higher elevations, they usually have uh, fire escapes and things of that nature. And you really wouldn't want something preventing the window from opening, because then if there's a fire in the house, how the hell you get out? You'd have to smash the window maybe. All right. Buildings with three or more units, landlords must install window guards unless the tenant indicates in writing that they do not want them. Okay. And the landlord needs to get that in writing every year before February 15th. They must have the tenant fill out a form about window guards. And then any installed window guards must be inspected twice a year, once between March 1st and May 1st, and again between September 1st and December 1st. And they need to keep a log of the inspections and the maintenance of these window guards. Now, if somebody has window air conditioning units installed in the windows, um, they must be installed, those AC units must be installed with one-way tamper-resistant screws. So it's one-way screws. You need a special tool to get them out in order to bolt the AC securely to the window frame as well as the window guards. You they need to be installed with those special one-way screws as well. So there must not be a space greater than 4.5 inches that a child can slip through. And the landlord can charge the tenants up to $20 for each window guard installed. Okay.
Do we have to remember all these
No,
dates?
you just need to know this stuff up here that's in the box at the top.
Okay.
This stuff for additional units, you're not going to get any questions on exam about that. Okay. You
Okay.
just the stuff in the box up top here. So you may want to take a screenshot of it because it's not in the book anywhere except in the actual lease contract section 36 that I had you put a highlighted box around. Okay. Everybody good? You got a screenshot or a picture? Okay. So here's
Why
what went.
only why only on first floor? Why not on other floors?
Well, because you could get hurt if you fall 6 feet to the ground.
So if you are living on the second floor, you
Well,
can
you
fall
just die.
too. Yeah,
Oh,
so it
yeah.
no, go back to the
What
last
if it's
slide,
a
please.
13th floor? You
Yeah.
fall out. There's a hell of a hazard there, right? But
Just please
you
go back to the last slide.
yeah,
Only required on first floor units if window sill is at least 6 feet above grade,
yeah, yeah.
and not on other floors.
This is the way the politicians wrote the law. Yes, it's only if there is a hazard present. Okay,
Okay.
I would I would think the added elevation would be the hazard, you know, but that's me. you know, um, Look, a lot of these buildings could have fire escapes. So they got fire escapes. You wouldn't want a window guard there because you wouldn't be able to get out onto the fire escape because it prevents the window from opening more than 4.5 inches. You know, I guess that may be the rationale behind it. Uh, yeah. Let me ask and see if we could get a better answer from AI. Let's see if we can get AI to give us a better answer. Why does Jersey only require window guards installed on first floor units when the sill is at least 6 feet above grade and not on higher floors? Let's see what AI tells us. It's thinking, it's thinking. So you see what I typed there? Because New Jersey window guards rule is triggered only when a fall hazard exists, and a first floor window with a sill more than 6 feet above grade is considered a fall hazard, while upper floor windows are always considered hazardous. So they're already guards when qualifying for qualified tenants request them. So they already require guards. Okay. So sixth floor measurement applies only to first floor units because some first floor units are close enough to the ground they would not cause serious injury. Ah, okay. So I guess because automatically other floors automatically have them. So it's a question, do the first floor units require them? Only if it's at least 6 feet above the ground, because that's when it would be a hazard. That's the answer. Okay, that makes a little more sense when it's explained like that. So the law request is request based, not universal. Okay. The only special exemption applies to first floor units if the sill is above 6 feet above grade. Okay. Any higher floor, automatically a fall hazard. Guards are required when requested. Got it. Here, I'm going to actually steal that code right there. We could add that to the slide. Oh, it's window guard. So, fire level. All right. So there we go. It's good. It all fits. And we got further explanation there now. Only required on first floor units if the window sill is at least 6 feet above grade. Period. Higher level units must be automatically installed on higher level units. They must automatically be installed if the tenant requests it, because there is no question that there is a hazard. Okay, and that's according to that code. Okay, actually, window guards, I'm going to put that right over. Ah, dang it. That's all right. We'll move stuff around a little bit. Still make it fit. Here we go. And yeah, what's going on over here? That's all getting screwed up. That's why. Doobie doo, doobie doo. Bueno. And hopefully that looks good on screen. I don't know. Looks like something shrunk there a bit. Good enough. Full screen and back. There we go. Yep, that looks good. Let me require first. Yeah, I thought there was an underline underneath all this. Remove that. Okay, there we go. Adjustments made. Sorry about that. So if anybody wanted to get a screenshot of it with that additional explanation put in there, and I put the code there pertaining to window guards. Okay. Not that we need to know them for the codes for exams in the law, but all right. But now we got a better rationale of thinking why only on the first floor unit? Well, because the first floor unit is questionable. Does it need it? Is there a hazard? And it's only a hazard if it's 6 feet or more, if the window sill's 6 feet or more above the ground. All other units are automatically considered a hazard. So if the tenant requests it, they must be installed. Okay. But they don't get installed automatically. It's only at the tenant's request. Okay. And this is the way window guards look from the outside. This is the way they look from the inside. If you have one of those swinging doors, a window guard would just be an L bracket. Okay. And on windows, it could be an L bracket, or on some windows, like you get the vinyl windows and such, there's actually something there with the screwdriver. You could actually pull it out and snap it into place. It's that snap can't be pushed back. So be sure you want it out. If you pull it out, you pull out these snaps, and it prevents the windows from opening more than 4.5 inches. Well, at least above the where the window guard is. Okay, so here's where the window guard gets installed. There's no gaps in them more than 4.5 inches. but it's a bar there that allows you to open the window more to get fresh air in, but just no gaps more than 4.5 inches. And they use those tamper resistant one-way screws. All right, typical lease provisions. You got the term of the lease, the use of the premises. You got to specify the agency relationship, just like in the sales contracts. The first time we ever do that with somebody is by giving them the CIS form, right? The Consumer Information Statement. That needs to be given to all tenants, except for short-term rentals less than 125 days, which are considered seasonal. It's not required for commercial properties, only residential. Opinion 26 notice, just like on the sales contract, needs to be on the cover page of a lease contract. Needs to be on the cover of any contract prepared by licensees. And what is the purpose of the Opinion 26 notice? To tell people that they have a right to hire a lawyer. Even though most people don't use lawyers for leases, they have the right to, and they could. Uh, let's see, for the federal paint disclosure, there should be a disclosure in the contract, the lease contract itself, but we also give a separate disclosure, that lead paint disclosure statement that needs to be filled out if the property was built prior to 1978, the year that lead paint was banned. And we need to give the pamphlet and an opportunity, a 10-day opportunity to conduct the lead inspection or waive that opportunity altogether. Those are the three things we need to give to tenants in buildings with built prior to 1978. Okay. And there's that lead disclosure statement that we use, one from the New Jersey Realtors. Okay. Needs to be filled out first by the landlord, because the section down below where the tenants fill out, the very first question it's asking is, did they receive all the information from above in section 3? How could you have them initial next to that if the landlord didn't fill out the section 3 yet? So make sure it's filled out properly in the proper order. Okay. That's just a continuation of the lead statement for the last item that they needed to initial next to and check off that they received that 10-day opportunity or they waived it for the lead inspection. And then the renters or buyers would sign and date, and same thing with their agent. Here's that lead hazard pamphlet booklet showing you all the different damage, health hazards that the lead can have when exposing the human body to these heavy metals. And it's children, especially those under the age of 6, are very susceptible to these things because they're still developing. So mental issues, the what do you call it? It's got it here somewhere. Their nervous system can have serious issues. It cause a lot of problems. Decreased intelligence, speech issues, poor muscle coordination. Okay, a lot of issues. So don't eat the lead chips. All right. Now, New Jersey, not to be outdone by any state law or federal law, created its own state law that requires inspections. Okay. The federal law doesn't require inspections. It just requires the disclosure of any known lead hazards. You could inspect if you want, but it's not required. You guys remember, how do you inspect for lead? The cotton swabs, with the chemical. If it turns red, it's lead. Or you could take off a piece and send it to the lab. Or on some larger scale, where you need to test hundreds of units, perhaps, they have an electronic device. It's like a portable lab that they stick a needle through the different layers of the paint, and it'll give you the measurement, how much lead is in there, if any. Yeah. I know this because I used to be a superintendent of an apartment building, and the new insurance company that the owners got wanted to check out every unit and they wanted to poke a hole, a pinhole through the wall in every apartment to take a lead level measurement there. Um, okay, so every tenant, okay, we're already past July 24th, 2024, so it doesn't matter. Every rental unit is required to have been inspected to make sure that there are no lead hazards present. The only ones that are exempt from this requirement are those buildings built after 1978, certified free of lead paint, single family and two family seasonal rentals, units located in a building with three or more units that have been registered lead free and have no outstanding violations in the last 5 years, and had lead safe certificates issued in the last 2 years. Security deposits. How much security can your landlord legally collect by law? Everybody knows this, right?
1.5 months.
1.5 times the monthly rental figure. Yep. So, what is security? It's a guarantee that the rent's going to be paid and to cover any damages. Although tenants can do damages well in excess of 1.5 times the monthly rental figure, especially if they're malicious about it. Money must be placed in a special interest-bearing account used only for security deposits. Tenants must be notified where that money is being held. The tenant must get their interest earned, paid, or credited to them on the anniversary of their lease every year. The penalty for the landlord could be that they are required to pay double the entire security deposit. That's a lot more than what they're going to be paying on interest. So, but it's meant to sting because it's the tenant's money. They should be earning the interest on it, not the landlord. Maximum security deposit required by law is 1.5 times the monthly rent for residential. There is no maximum security defined by law for commercial real estate. It's whatever you get away with. And asking 3 months is not uncommon. No pet security can be charged as long as the total security deposits do not exceed 1.5 times the monthly rental figure. You could come up with it and call it something else. It's still security. So the total security deposits must not exceed 1.5 times the monthly rental figure. And be careful calling it pet security if somebody has a service animal, because they could say, oh, it's not a pet, you know. So just call it security. Okay. Avoid the problem altogether, because the total security can't exceed 1.5 times the monthly rental figure, but you're allowed to charge up to that. So security deposits have to be returned to the tenant within 30 days of their lease termination if there's no damages. So the penalty for violating this rule would be double the entire security deposit to the landlord. That would be their penalty for not returning the money to the tenant. What if the tenant moved out? They didn't tell the landlord where they moved to, though. How does the landlord return the security deposit? Tenant just left, but you got the security deposit still. They didn't leave a forwarding address. What do you do?
Party.
Party. Oh, no, 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 no.
I don't know.
You mail it to the last known address, which is the unit that you were renting to them. Because they may have not given you a forwarding address, but they may have set it up with the post office. You follow? And therefore, if you send it to them in the mail, it could get redirected to wherever they're currently living now. But if it doesn't, and it just comes back to you, don't open it. Keep it closed, but that's your proof of delivery that you tried to return it if they ever come back and try to say something. Okay? Wanting their security deposit back. You'll still have to give it to them. But if they try coming after you for more, you've got the proof that you tried to return it to them, but they left no forwarding address. You could also go to the court and try to ask the court if you could keep it. But usually if there's no damages or anything, it's no. So what would you do with that money then? turn it into the state to the missing money fund. Goes to unclaimedproperty.nj.gov. Most landlords wouldn't don't know about that or don't do that. They just keep it. You know, just be aware that if the tenant makes a request later on, you got to give it back to them. Okay. And deductions for damages must be on an itemized report. You can't just say, we're keeping your security deposit because you screwed up my place. You damaged my place. Okay, you need to give an itemized list of those repairs and how much each repair costs. There was a hole in the wall from the door. There was garbage left behind that needed to be cleaned up, and how much the cost is to for that. You left furniture behind that needed to be disposed of. How much did it cost you to do that? Uh, Et cetera, et cetera, et cetera. You know, you could charge as much as you want, for the within reason for cleaning up an apartment or having to remove debris. Hey, you need to get a friend to help you carry that couch out to throw it out to have the city come pick it up if they would pick it up. You know, otherwise you would need to arrange other ways to dispose of it, and it could be a cost. So you could put that as the itemized list. Um, so if the property sold and the landlord must turn over security deposits to the new owner and notify the tenant where it's being held because it's their security. I don't know if I should bring this up now or later. Stuff that tenants do. Let me see. I guess I could bring that up during maintenance of premises. Or we just talked about security deposits. Maybe we could bring it up now. How about that? So do the highlight of the security deposits here.
So recently, I watched a video where the tenant was not paying the rent,
Uh-huh.
and then I mean, when they left, the whole house was in mess. I mean, half of the room was filled with filth. So the owner was recording the video and shared it with in public. So what happens in that case? I mean, here the landlord suffers, right? Uh, I mean, there is no
It's part of doing the
security for such kind of.
well, security deposits are for damages,
That is
but
for 1.5 months only. But if they were already
if
not paying
damages
the
exceed
rent,
that, right?
yes, yes.
What do you
So
do?
they have to
You got
redo the whole house and
you got to
they
chase
damaged
after them.
everything.
You got to chase after them. You should. It's also a good idea for landlords to put in their lease agreement that it will be reported on their credit reports any damages or non-payments, you know, late payments and things of that nature. So the tenant is aware that you're not just, getting their payment late, but you're also um, going to be reporting it on their credit report. See, most landlords don't do that, so tenants don't give a crap. But if they know that it's going to be affecting their credit, maybe they'll have it'll be more important to them. Let me see. Let me show you some pictures of damages by tenants. Oh, I got so many of these things. Water damage. Now this one's been done by tenants, so I'll put this one out there. Uh, I'm going to put it on a slide, but do your highlights right now. I'm going to take a couple of these and I'm going to put them on the slide. There's several images I have here, so we'll start off light and work our way up to these damages. Oh, jeez. Yeah. There's bad tenants out there for sure that cause damages for sure. And I'm just putting together some slides right now with some of those pictures for you. You may get a kick out of it, maybe a little disgusted by it, but hey, stuff that happens. Trying to put like 4 pictures per slide here this way. And yeah, so this is just one apartment that I've dealt with before. I've dealt with far worse than this too. All right, you'll see what I'm talking about in a moment. Two, 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 and one more. The, I've got I got pictures of not just damages, but um, garbage left behind by tenants. So take a look. Holes put in walls everywhere. Look at this. This is there's no door that goes here. It's not a door handle. It's somebody punching a wall. Look at this. Old food boxes and crap laying all over. The door completely missing from the bathroom. The toilet seat like ripped off its hinges, just sitting there. Oh, and don't forget the bong that they left sitting there on the on the kitchen sink. I guess they smoked their crack or their weed or whatever they were smoking there while they're sitting on the toilet in this filthy house. Look at that. All this garbage just left there, collected. Yeah. Invite for cockroaches and other rodents, right? How could you live like this? Not take out your garbage for crying out loud. But this was an apartment that was just recently renovated too. These people destroyed the place. Uh, the cabinets were messed up. The You've got the brand new microwave and stove. The microwave was screwed up. The door for the refrigerator was screwed up. Sometimes people are just pigs. They're disgusting. It is. And here's the garage. They're probably a stolen motorcycle. Look at all the garbage just thrown all over in the garage, filling the garage too. Landlord had to get rid of all this. It's gonna that cost them some time and effort to do. And where do you put it to get rid of it? Need to get a dumpster, put it out special pickup for the city. Will the city even pick it up? You know, yeah, it's that's an issue. All right. So late payments can be charged to tenants. Um, However, certain tenants must be given a period of time, a 5 day period of time, free from any late fees or penalties. Those tenants so qualified are those that are receiving Social Security benefits, those dependent on old age railroad retirement pensions, and any other governmental payment or quasi governmental payment, pension or payment. Like if you are relying on the government to pay you, and that is what the money is that you're using to pay the rent, um, then the landlords can't hold you responsible for paying the rent late because you're relying on the government's payment. And if the government pays you late, or the your pension program coming from the government, or whatnot, Social Security payments or whatever, you know, usually rental subsidies are paid directly to the landlords through direct deposit, so that's not an issue that comes from the tenant. But if part of the rent needs to be paid by the tenant and the tenant is relying on a payment from the government, then landlords must give them 5 day grace period free from any late fees or penalties. Okay. Always check local rent control laws before charging any late fees or penalties that could restrict you from doing so or limit how much you can charge in late fees or penalties. You know, some municipalities have rent control. These laws are meant to protect tenants from abusive landlords, but it's a double-edged sword there too. So let's highlight late payments in the book, page 239.
So, landlord can ask new tenants for their credit history.
Uh, yeah, you should get their social security number so that you can run their credit, do a background check, a credit check on them. Credit
Okay.
and employment check. Have them fill out an application. Where are they currently employed? And ask, uh, do you have permission uh, to call to verify their employment and their references? You could ask for references and employment. Um, the references they'll probably give their friends or something, but you can call their employer up and ask, verify their employment. The employers probably won't give you any dirt on them, but you never know. Maybe they will. Maybe you could ask, but that shouldn't be going down. I think with that, you should just be verifying their employment, how much they make, and that they are full time employed or whatever. Okay, so tenant cannot take possession until the premises until the specified date on the lease. You as the real estate agent, you definitely should not give them access to put some of their belongings in the property before the lease date starts, no matter how much they beg and plead. Oh, I just need to put a couple things in there. I got nowhere to keep them right now. Put them in your trunk. It's not our problem, right? Well, it's not the landlord's problem. Don't mean to be rude to you or anything, but technically, I let you put one bag in there. You're in possession of the premises, and your lease date hasn't started yet. I could lose my license for that, and it could cause all kinds of legal possible complications with the landlord. I don't know what your intentions are. Um, so we cannot allow tenants to put things in earlier before the lease inception date and before the city inspections as well, right? So licensees should never give a tenant keys, even to only store a few belongings there before the lease term begins. You could be risking your license by doing so, and you could be causing problems for a landlord where before they get the money from the tenant got possession of it, and now say they don't want to get out. Um, Landlord needs to evict them. So now you got a tenant that got in there, never paid any rent, and they they need to be evicted, and you allowed this situation to happen. Landlord may come after you for payments or damages as well. See how it could cause a problem for everybody involved? Don't let anybody have early access to the premises just for showings, not for moving in or putting a couple of their belongings. Okay, we went over this one before with the legal principles of a lease. When a tenant, the landlord's, uh, one of the landlord's employees were using their pass key to go into the apartment and playing around with the guy's fiance's underwear. Um, he went to the police department, tried to file a complaint. They said, "Oh, there's nothing you could do. He has a right to be there." Well, not, uh, no, he doesn't. If he read his truth in renting booklet, it specifies what the rights are of the tenants and obligations of landlords and their agents. And under the criminal code for defiant trespass in New Jersey, that landlord's employee could have been charged. But it looks like the tenant wasn't. Uh, he seemed very mild and laid back, so didn't look like that ever happened. But your landlords and uh, their employees, they can only use pass keys to enter a rental unit with the tenant's permission in advance, or for emergency situations only. They can't just use their key to walk into your apartment anytime they want. Because what is a lease? What is a lease?
Personal property.
It's what?
Personal property.
Okay, not what kind of property is it, but what exactly is a lease? What does a lease do? What is the purpose of a lease?
Um,
It's a situation where the landlord uh, not only conveys their property to a tenant for a period of time, it's a document where the landlord transfers their rights to the tenant for that period of time while they're occupying the property, except for the rights to mortgage the property or sell it. So remember the bundle of rights you get as an owner? The owner passes on a lot of those rights to the tenant when they're leasing. You know, the right of exclusion, the right of quiet enjoyment to keep others from entering your property. So the landlord, even though they own the property, they transferred those rights to the tenant during the lease term. They can't just go onto the property without getting the tenant's permission because it's their property now during the lease term. So they have the right to keep others from entering it or occupying it. So
so, but then when they are not, I mean, fulfilling the needs of the deal of the lease, I mean, they are exploiting the property and damaging the property, then there is no law for that. I mean, only credit
evict them,
history.
evict them
Evict.
to
So,
revoke
I mean, uh,
their rights. The landlord, if you wrote it in the lease, which you should to get a good lease, um, you could write in the lease that the landlord has the right to call for an inspection to inspect the leased premises um, by giving a 24 or 48-hour notice. Okay, that's fair enough. That's a fair enough amount of time. And you wrote it in the lease. The tenant agreed to those terms before they moved in. So now you could use them and exercise them by putting a letter in their mailbox, or slipping it under their door. Hey, within 24 or 48 hours, I need to come in to inspect the premises. Okay. Or we will be coming in to inspect the premises. Okay. And then you could come in and inspect the premises with the tenant there or not. So I don't know if you guys remember this. I don't know if I played this all before.
With more on this story, Erica. The couple tells us they purchased this security camera to just watch out when anyone was in their apartment, but never expected to capture an employee of their building going through their underwear.
Yeah, I think we did go over this in chapter 4.
Take a look.
It said there was a notification for motion, so I checked it.
The Rivington resident Alex Sacchetti says he was at work just a few weeks ago when his security camera in his bedroom captured moments a maintenance worker did something out of the ordinary.
I started watching, and the man was, going towards the dresser. I was like, wow, that's strange. And then he opened it. He was going through my fiance's underwear. And, after I watched the entire event, there was potentially other lewd acts that took place, but mainly just going through my entire apartment.
The worker is seen checking the bedroom door, closing it, and turning off the lights before going into the corner of the room, blocked by pillows on the camera. Sacchetti says he quickly called management and alerted them. That's when this moment shows the man looking at the camera when he answers his radio call to leave the unit.
It was pretty much your whole privacy is violated.
Sacchetti says his fiance has been so upset by the situation, she's staying elsewhere for now. They filed a report with Hoboken police, but were told this.
He had the right to be in here, and apparently anything that took place is not a crime.
The two have been back and forth with Equity Apartments, who owns the complex, but says their responses have been lacking empathy.
There's been some outreach from some sort of manager or something, I'm not exactly sure. But as far as oversight or, hey, so sorry this happened to you, none of that.
And while this situation still leaves him uneasy, Sacchetti says it's a warning for others.
People here or elsewhere that have buildings should just have some sort of surveillance to fall back on.
And the couple tells us they're hoping to switch apartments in the near future. We did reach out to Equity Apartments for comment, but did not hear back.
Yeah, shocker. They got away with it. Yeah, but if he knew the rights, if he read his truth in renting booklet, being in a building like the one that he was in, he should have been issued one of those truth in renting booklets. In buildings with 3 or more rental units are the ones that are required to be given those. He would have known his rights by reading that truth in renting booklet. Okay, it's available both in English and Spanish, by the way. I shared with you, I believe, this link already once before, the truth in renting booklet. The landlord should give it to tenants. It gets updated periodically too, so it's not a bad idea to just print them out, or you could buy them pre-printed, or just supply the tenant with a link to it. But it's good to also have them printed out, so tenant can't say, well, I'm too poor to have internet, I don't have internet access, so I wasn't able to see it, So having them just initial next to it that they've received the link to get it may not be good enough that you gave it to them. So you should provide them with a printed copy of it as well. Okay, so improvements require the written permission from the landlord, even if just painting of the unit, because people got some wacky taste in colors. I've seen people paint some apartments in strange colors, difficult colors to paint over. I've seen them paint their rooms black. You know how hard it is to repaint over black paint. Or I had one tenant, she was a Hello Kitty fanatic. That Hello Kitty pink. She wanted her bedroom painted that color, and the landlord allowed her to, but with the agreement that she was responsible for painting it back to a neutral color when she moved out. But when she moved out, she was like, I don't have time for this. You just do it, So I was like, okay, I'll do it. Landlord's going to pay me for it anyway out of your security deposit. So I went in there, put some primer over it, painted over it, and pink bled through. Okay, couple more layers of primer, couple more layers of paint, kept bleeding through until I went over and I got one of those expensive type of paints to put over there. Like those Valspar 1 coat of paint and primer it is. bled right through that expensive paint. So I asked the guy at the paint store, I was like, what the hell do I do? I was like, the color keeps bleeding through. I must have like 9 layers of paint on this thing already. And he started laughing. He's like, yeah, when you get those wacky colors like that, the only way to cover them up is actually to go with a primer that's dark colored. So it's like a dark brown colored primer that you have to go over, and then you could paint over that with the lighter color, and then it'll just cover it up. So I had to do 2 more coats. I'll go to the primer, the dark primer, and then the paint. And then she got shocked when she didn't get any of her security deposit back. I was like, well, I only had to put like 10 coats of paint on it, to cover up that, it was your responsibility to do it. You didn't do it. I was like, I was having trouble trying to cover it up. I was like, so you should have painted it. You didn't. It is what it is. Um, so uh, any improvements require the written permission of the landlord. That a lot of times people want to change light fixtures too. They want to put in ceiling fan light fixtures. All right, landlord may give him permission to do it, but should put a stipulation in there that needs to be done by a licensed contractor, licensed electrician, so they don't burn down your house or improperly wire something or electrocute and kill themselves. The landlord's responsible for. And Can a tenant, if they put in a improvement like a fixture like that, can they take it with them when they leave? They got
We should
they
be
got
able to, or does it have to
Yes.
be written? Yes.
it's a fixture. Fixture is part of the real estate. If the landlord gave you permission to upgrade the fixtures, you can't remove them when you leave.
Really?
You would need the
Business.
landlord's written permission. You would need the landlord's written permission to do so. And why in the hell would they give that to you? Think about it for a second. You had to get their permission to remove the light fixture on the ceiling to put in a ceiling fan light fixture. Why would they
Okay,
give you
sorry, you're
permission?
talking about the residential units.
Yeah, yeah. Why
Ah,
would they give you?
no, no,
Yeah, yeah,
that's not allowed. Yeah.
yeah.
For business purposes, it's
What
allowed trade
about,
fixture.
yeah,
Well, that's a
commercial?
trade. Well, that's a trade fixture, though.
Mm.
Yeah, because trade fixtures are, even after they're installed, they're still considered personal property used to conduct the business. As long as the tenant removes it before the lease expires, it's fine. But they can't go, you know, uh, after the lease expires, go back in there trying to remove it. They got to get it removed before the lease expires. Uh, the tenant, let's see, if they don't, then that trade fixture becomes a fixture, which is a part of the real estate, and they can't remove it. Okay. So in the residential real estate, they can't remove those fixtures unless the landlord gives permission to do so. But once again, I don't know why they would, you know, give you permission to do an upgrade just to have you rip it out later. Hmm. Could that be considered damages that the landlord can then charge you out of your security deposit for? They give you permission to put a ceiling fan light fixture in, and then you rip it out and take it with you when you leave. Yeah. Okay. So some examples of trade fixtures are barber chairs, gas station pumps, sinks in beauty salons, shelvings in the stores. But when they move, they can't just like pull out the sinks and leave the pipes leaky there. They need to cap them off behind the walls like the premises was when you first got it. So let's write there in the book on page 240 above improvements. I'm not sure if it says tenant improvements or what they're. Just write trade fixtures, tangible personal property / chattel. It is customary to provide that such trade fixtures may be removed by the tenant before the lease expires, provided the tenant restores the premises to the same condition that they took possession of. Okay, that's for trade fixtures.
So in case the tenant leaves the trade fixture deliberately and do not remove it before the lease gets expired. So in that case, owners can deduct the security deposit from them.
No, no, not
Why?
only for only for
So
damages. It's not like they left furniture behind. It could be, you know, the sinks and ceiling fans. Any new tenant is going to remodel the commercial space to their liking and for their needs as well. So
okay,
generally, landlords, they don't give a crap about that
okay.
as long as there's no damages there. You know, look, we've had people where there was beauty salons and their place was as a beauty salon. They didn't take anything out of there. They left pretty much all that stuff there. So now it's easier for the landlord to uh, lease out
To
ready-made
another saloon,
beauty
right?
salon, ready to be open. You know,
What if someone comes and asks for, you know, a yoga room or yoga studio, and they have to remove it? Then
yeah,
whose responsibility comes?
yours. The tenant. You know, the tenant wants to put in. They want to reconfigure the space for their business purposes, their business needs. Well, then reconfigure the unit. What do you want from
Okay.
me? You know, as the landlord, I'm playing, the part of the landlord. What do you want from me? I'm not going to do it. You do it. You know,
So they will return the security deposit to the first tenant, to the last tenant,
if
and
there's no
okay,
damages, correct.
if there are no charges, yeah.
No damages and no late payments or no missing payments, for rent. Correct. Okay. So leases carry an implied warranty of habitability that states that there's no condition present that could cause um, a hazard to the health or safety of the occupants. Um, the tenant must return the premises in the same condition as it was received. Landlord is responsible for repairs unless specified otherwise in the lease. Then the tenants are responsible for damages usually. Um, the DCA, the Department of Community Affairs, inspects buildings with three or more units, not counting the unit that the owner lives in, at least once every 5 years. That state inspection, the industry lingo for it is, they call it a green card inspection. So if you guys ever hear green card inspection, it has nothing to do with immigration. It has to deal with, it's just the industry's lingo. Because when they got the state inspection and it passed the state inspection, they would issue a pass certificate that would then be hanged on in the hallway walls. Um, it was green in color on a special water. Um, what do you call it? That had this water type ink on there, made it specialty paper with the state's logo on it and such. Anyway, so that's where it got the term green card from. But that's a state inspection that's required once every 5 years for buildings with three or more rental units, not counting the unit the landlord lives in. Now, if the rent is withheld by a tenant to force the landlord to make necessary repairs due to uninhabitable or dangerous conditions, it should be placed in an escrow account to pay the landlord later, because the tenant doesn't just get to not pay rent until the repairs get done and then start picking up paying rent from that day forward. They got to pay the landlord all the back rent that they've been withholding from them to try to force them to do those repairs. And this is where tenants get a little bit of information, and a little information can be a dangerous thing because you don't have the full story. You're not allowed to just withhold paying rent, then start resuming after they do the repairs. You got to pay the landlord back all that back rent. And this is where tenants usually get evicted because the landlord takes them to court and they didn't keep all that back rent. And so they didn't have it to pay the landlord. So therefore, the judge would order them evicted. They don't get to live there for free. They were just withholding the rents. So let's highlight that now. Page 240, implied warranty of habitability, with the green card inspections about here. And there's a paragraph here about repairs. Now, New Jersey does recognize the tenant's rights to repair and deduct. This is where tenants also think that they're bright sometimes. They figure they'll do the repairs or have their friend do the repairs and just say, hey, just give me a big bill, big overinflated bill that I could, really screw the landlord by charging them a high amount to do these repairs. And landlords are going to tell you to go screw yourself. You need to pay the rent. And it is the tenant's responsibility if they are going to do a repair and deduct on their own. It is their responsibility to save the landlord money. So they should get at least 3 price quotes, realistic price quotes, not 3 overinflated price quotes, because the judge will look at it. They'll be like, these aren't common costs for this, and they'll kick it out. So if you do the repair and deduct route, make sure you get 3 legitimate quotes, price quotes. Try to save the landlord money before doing any repairs. Okay. And make sure that you first notified the landlord, giving them the opportunity to do the repairs first. You know, they may have their own superintendent there that could do the stuff, you know? So New Jersey does recognize the tenant's rights to repair and deduct from the rent the costs of those repairs. If repairs are vital and the landlord doesn't make them in a reasonable amount of time, and you notified them, because they're not mind readers, they can't just, you can't expect the landlord to fix something if you never told them it was broken. Sometimes tenants get angry at landlords and they never even notified the landlord. It's odd. Have repairs done and deduct them from the rent. If the rent is withheld, it should be held in a special escrow account to pay all that back rent back once the landlord makes all those repairs. That's why they say here, nothing should be done without consulting an attorney first, because a lot of people, they learn about these laws through the grapevine and they really don't know how it works. And they end up getting screwed because they got those do the repair and deduct route from the rent, but they overcharge the landlord for the cost of those repairs, or they withhold the rent and then just tried to resume paying the rent, but they didn't keep all that back rent and pay the landlord when he did the repairs. Okay, now where the landlord furnishes heat between October 1 and May 1. So if heat is included, if the utilities are included in the rent, between October 1 and May 1, all rooms must be heated to at least 68 degrees from 6 a.m. to 11 p.m. and at least 65 degrees at night. I've had some people in class say to me, oh, that's cold, that's freezing. No, it ain't. That ain't freezing. All right. Freezing's 32 degrees, right? So that's not freezing. It's included in the rent. That's what you get. You know, now when a tenant's not paying rent, but those utilities are included in the rent, the landlord still has to maintain the heat at these temperatures. Okay, so they can't shut off the heat or the water for you. They have to keep them on. That's why landlord is better off separating the utilities and billing them separately. Okay, everybody got these highlights in the notes? We're still working on it, or you got it? Let me know. Yeah, no? Any more time? Good. Okay. All right, so that state inspection, that green card inspection is required once every 5 years, right? It's required for buildings with 3 or more rental units, not counting the unit the landlord lives in. State inspector from the DCA comes out to do the inspection, the Department of Community Affairs, and these guys always find stuff wrong. It can be new construction. They're going to find something wrong with it. Trust me on this. I got a friend that's a state inspector. He's got like a permanent stick wedged up his butt. Yeah, it's the way these guys are. They're sticklers for the rules and they know them. They're constantly taking classes on this stuff. They're tough cookies. So the state inspection must be performed at least once every 5 years for buildings with 3 or more rental units. However, hotels and motels, they must be inspected at least once every 3 years, and they're allowed to have spot inspections that are unannounced without prior notice. Okay, so you need to know this for exams. How often are the state inspections done on the buildings with three or more units and on hotels and motels? And when you pass it, they give you that it's a state inspection. Okay. The green card part, you're not going to get on exam that for the lingo, but you need to know that for when you get out working in the business. Another agent may say, is the green card up to date? You got to know what they're talking about. They're talking about the state inspection. All right. And about landlords maintaining the heat. This used to be an exam question years ago. I haven't had any students come up to me and tell me that they heard it on exam. So I wouldn't know if it's still an exam question unless they did. But I haven't heard any students tell me that this was on exams anymore. All right, you remember assignment and novation, right? Assignment is where a tenant or when one party transfers their rights and obligations of a contract to another party, it becomes their responsibility now. However, if they don't follow their responsibilities, the original party to the contract is still responsible. They never give up their liability unless they novate the contract. Novation would relieve the tenant from any further obligations. So you could novate the parties or you could novate the contract. That's substituting the contract, an old contract, with a new agreement. Or novation of the parties, separating a party named in the contract or replacing a party named in the contract with a new party in the contract, where the original party to the contract no longer has any further legal liabilities or obligations. Okay? So subleasing transfers those rights to another tenant if the landlord allows it. Our leases forbid subleasing. A landlord would have to specifically put in writing that they're going to allow you to do that. Or even if a contract says that the tenant cannot do that, the tenant can always ask the landlord, and the landlord could agree to it. Okay. Let me throw out the morning attendance poll really quick. All right. And remember, with destruction of the premises, any damages done by the tenant are the tenant's responsibility. Repairs are one thing. The lease should state who's responsible for making any repairs. But damages, that's on the tenant. Did you like those pictures I showed you of the tenants doing damages before or leaving their garbage behind? It could be worse. I've seen worse. You know, um, this landlord for this property that I showed you all those pictures of, he had it bad. Those tenants, they actually uh, didn't pay. He had separate utilities for the different floors. These tenants, what they did, they stopped paying their utilities. The landlord had utilities on though for the other apartment and the common areas. This tenant went and switched the electrical to supply the other apartment, and they switched the water heater heat to the hot water to go to the other apartment by changing the piping and by changing the wiring of the house. I mean, if you have the knowledge to do such a thing without killing yourself, that shows you have some sort of abilities. Why be such a scumbag like this? Why not just get a job working as an electrician or as a plumber? They pay very well. You know, it's amazing to me how people who are scammers or thieves like this, they're sometimes they're smart people, but they do dumb things. They use it to break the law and to rip others off instead of using it uh, like others do. I guess maybe they don't want a full-time job. They just want to get stuff for free all the time. But this landlord had it bad with these tenants. He eventually got them evicted by sheriff's officers, had to pull them out because they were still resistant, even by the cops. And now he had to clean up all that crap out of there. And then he needed to pay to get everything redone again, all the sheetrock work and this and that and the other thing. And then he got to it was just a nightmare. And then after he got them all out, one of the contractors, somebody who was working for the contractor to get all the work done, had a drug problem and overdosed in one of the bathrooms. And I walked in and found the guy dead in there. You know, yeah, that's great. So um, hmm, now you have a now you have another thing to possibly disclose. Yeah, somebody died in the bathroom here. Overdosed on the toilet. Yeah, you heard that in the news lately. Yeah, that was this house. So, yeah. All right. So, notice to quit requirement. Let's highlight this on page 241. This is how much notice the landlord or the tenant needs to give so that they are neither is in breach of contract, but to legally be able to terminate. Remember, anybody who terminates a lease early would be in breach of contract, but certain notifications required to terminate certain leasehold agreements, like the tenancy at will, periodic estate. Those require advance notice. So, estate for years, no advance notice is needed. Tenancy at will, 3 months. And periodic estate depends on the length of the lease term. Week to week, month to month, or estate for years, 3 months notice. Okay. Truth in renting booklet. Who do we need to give it to? Once again, tenants in buildings with 3 or more units, not counting the unit the landlord lives in. Now, do those rules in that booklet also apply to people living in 1-family and 2-family houses? A lot of them, yeah. But they're only required by law to give it to tenants in buildings with 3 or more units, not counting the unit the landlord lives in. So 3 or more rental units available. So the DCA does those inspections, remember? Does not apply to commercial real estate, the Truth in Renting booklet. And here you go. Here's a link to the DCA's website and the Truth in Renting booklet on in a PDF format as well. Okay. And I'll share that with you guys if you wanted it again for whatever reason. There you go. And it covers all kinds of issues from, tenants having problems, paying for utilities or insurance or anything, for legal advice for tenants, questions about, handicap accessibility or putting a satellite dish on the roof, or, having pets or service animals. I mean, it goes over all kinds of issues. Can the landlord walk into your unit? It covers all kinds of issues in those Truth in Renting booklet. All right. So beginning March 20th, 2024, every landlord must provide notice to prospective tenants about flood risks. This is interesting because lately on Facebook, I've been seeing videos posted by, politicians, one side of the party asking the other side questions about, they base the premise of all this stuff on what they call now global warming. Actually, no, they changed it because it was first global warming. Now it's called climate change. Okay, because global warming wasn't working when everything was freezing cold and we got a lot of snow. So they changed it to climate change, but it's still the same stuff. They're saying how the sea levels are rising at alarming rates, you know. And then you see online, you know, those historic pictures from when the Statue of Liberty was installed and then today, and it looks like the water levels are the same. Well, you know, different places, different parts of the world, they may be rising. Other places, they may be falling. Other places, they may be staying the same. Like at Plymouth Rock, you know, Plymouth Rock, or the Pilgrims, they first came to the United States. Well, that Plymouth Rock is still at the same level above water. Hasn't budged there a bit either. Hasn't been moved either. So where rental properties located in FEMA special flood hazard areas or moderate flood hazard areas, an actual knowledge that a rental premises or any portion of the rental premises, such as tenant parking spaces, have been subjected to flooding in the past. This needs to be disclosed to the tenants. Okay, and there's a notice there about the flood risk notification on the DCA's websites, in the Truth in Renting booklets, and there's this special notice that needs to be added now. We have it in our seller property condition disclosure reports when selling property, but here we could get it also on the website online. So here, if I were to click on it, it's just a form talking about the property. Are they in a 100-year flood zone or a 500-year flood zone? 500-year flood zones don't require flood insurance. 100-year flood zones do. Um, that just means that the property is likely to flood at least once every 100 years or at least once every 500. So that there's less of a risk of a flood in the 500-year flood zone than there is in a 100-year flood zone. Uh, has the rental property been flooded at all? And then the landlord needs to sign off on this. And then they go on to some kind of climate change rant here about the flood risks in New Jersey are growing due to the effects of climate change. Coastal and inland areas may experience significant flooding now and in the near future, including in places that were not previously known to flood. For example, by the year 2050, it is likely that sea levels will meet or exceed 2.1 feet above year 2000 levels, placing over 40,000 New Jersey properties at risk or permanent coastal flooding. In addition, precipitation intensity in New Jersey is increasing. No, it's not. At significant levels above historic trends. This really gets me that politicians are able to pass this as disclosures and requirements when it's not factual. They get a couple uh, of scientists that agree to tell, you know, say whatever they want them to say. There is no consensus in science, by the way. That's how science evolves and learns, you know. They question each other all the time. You know, the ones that come to a consensus, those are politically motivated folks. Um, so talking all this nonsense about, you know, increasing levels of storm intensity, that is totally false. You could talk to you could see videos online of the guy that created the Weather Channel and how he talks about what they did to his invention of the Weather Channel there, how this stuff is nonsense. Um, so these are let's see, these and other coastal and inland flood risks are expected to increase within the life of a typical mortgage originated after 2020. To learn more about this, go to flooddisclosures.nj.gov. Okay, so there you go.
So are the flood risk properties or the land are cheaper than the others?
No, they're just required to disclose it to you.
So
Or
why do people live there? I mean,
if
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 it
they're
is a high
per
risk zone. Sorry, yeah.
Okay, well, it depends. Where are they? Maybe it maybe they are in areas where it's more affordable because these flood zones could also be beat up areas with bad neighborhoods, high crime, and such. Or people would still buy them because even though they're expensive, because rich people can afford a mansion on the beach. If it floods, oh well, that's why we have insurance. And then they cry then when the insurance doesn't cover it, but that's okay. Why do you keep building on the side of a mountain that's likely to collapse into the sea? Why do you build in these places? Because they're probably beautiful. So that's why they keep doing it. And if insurance keeps covering them, well, there you go. And if insurance keeps covering them, do you know that uh, where I live right now, where my house is, zero chance of flood risk here. Okay. Um, I, I live inland quite a bit, elevated a bit, shouldn't be flooding here at all. Um, but yet, I'm required to pay for flood insurance. Not I'm not required to have flood insurance on the house, but your regular insurance policies now, New Jersey politicians several years ago allowed insurance companies, they made it a part and standard on all ones where people live in the coastal area. That's basically if you live less than 300 miles away from the shoreline, you're required to put into this flood fund. It basically helps subsidize the rich folks at the Jersey Shore if they get any floods. The insurance companies are covered because everybody contributes into that fund. So instead of just raising the insurance rates on those folks, they raise them on everybody contributing to it, even though it's not considered flood insurance that would cover me. It's a flood insurance like subsidy. So you can thank our politicians for that. Wondering why the cost of your homeowner's insurance goes up? There you go. Anybody notice spikes in car insurance going up in recent years? The uh, car insurance has been going up through the roof, and they claim it's because of the cost of everything going up. You know, uh, okay, so it's the cost of everything going up. Why is inflation that bad that the cost of everything went up that bad? Or is it just more that we have a lot of uninsured drivers that you're giving driver's licenses to also to folks that are illegally here in the country, allowing them to drive? A lot of these folks are not even getting insurance. All right. And they get into accidents. Um, who pays for it? You have the uninsured driver claim. Those costs need to go up now because somebody needs to pay for it. They didn't have insurance, it'll be your insurance. So everybody's insurance goes up that pays for insurance, that bothers to get insurance. You know, these are all contributing factors to it. So, but it's easy to tell a story how only one thing, just costs are going up. Yeah, really? Why? Act like a child. Keep saying why? Why? Are we there yet? Why? And then you can maybe get to the answers of some of these questions. But usually at the insurance company, that insurance agent that's selling you it won't tell you. But if you ask them, you say, well, is it because of this? You guys go to meetings in your insurance company, they tell you why they're doing these things. I know you don't disclose it to people, but and I was able to get a couple insurance companies to be like, yeah, and to tell me, because I had to vent a little bit to them when I'm paying that higher insurance rate on my vehicle. You know, why the hell do I got to pay for this? Flood insurance? What the hell? Why am I paying to a flood insurance fund, but it's not flood insurance that covers me? You know, oh well, because the flood map's being redrawn, and any place less than a couple hundred miles inland is at risk of catastrophic when there is a catastrophe for floods. They could possibly flood. Yeah, if we get a tsunami that brings us 500 feet in the air, the water level rises, maybe. But other than that, I'm pretty safe. But either way, we got these flood risks notice. We have these additional costs. And then the politicians try acting like heroes when they require you to disclose it. Okay. And in the meantime, it's all just a part of their the climate alarmist stuff that's driving up the costs. But yet they can't even tell us what the weather is going to be like next week. But yet they're telling us, sea levels are going to rise. All right. Anyway, enough of that. So here's where in the book where you would highlight about the truth in renting. I just highlighted the word truth in renting and wrote over here, required to be given to tenants in buildings with 3 or more units. Okay. You could just stop it right there, or you could add in there, not counting the unit the landlord lives in. Or you could just highlight this. The act requires residential landlords of dwellings with, I think it says 2 or more units, or more than 2 units. I think it says there in the book. So I crossed that out. I just wrote 3 in its place because that's basically why don't they just say 3 units or more? More than 2 units is how much? What's more than 2? It's 3. So just write 3. So you got 3 units there. So I think you're white out, put it over there and write 3 units, or more than 3 units if the landlord occupies one of the units to distribute, which that would make it 4 units if the landlord's occupying one of them, right? To distribute the truth in renting statement. So in buildings with 3 or more rental units, or if the landlord lives in it, it has to be at least a 4 family to require that state inspection. And you give those folks that truth in renting booklet. That's it in a nutshell. Anybody need more time for writing this? Anybody actually writing this? Just want to make sure I'm not sitting here if nobody's actually taking notes on it or doing these modifications in the book so that I could keep it moving. Okay. So disclosure of owners and managers to tenants and the municipality for emergency purposes. The names and addresses of the owner or resident managers must be on file with the local government and state agencies when they register the property for rental use. Yeah, this is why we required to get the fire inspections every time a tenant changeover. They make sure that the smoke and carbon monoxide detectors are there and working, and they make sure that the fire extinguisher, if they still have a requirement for it. I know our last governor, removed the requirement, the state requirement for fire extinguishers to be in the kitchens, but most municipalities, they kept it. So even though it's not a state requirement anymore, it is often still a municipal requirement to have that small fire extinguisher under 10 pounds rated to put out ABC type fires. Okay. So we also need to notify the tenants that federal crime insurance can be subsidized. It's available through HUD. But basically, what is federal crime insurance? Isn't it renter's insurance? Yeah. What is crime insurance? What does that cover? Does that cover in case you get stabbed when you walk out the front door? No. That's for like breaking an entry and crime in that way. So it's basically renter's insurance that's subsidized. I mean, for $100 a year, you could get like $60,000 worth of renter's insurance. So I don't know why you would need anything subsidized. Are you that poor you can't afford the $100 a year? I don't know. So they say it's available in high risk areas. Okay, well, do we have a list of these high risk areas here? Curiosity, I'd like to know. I'm sure HUD does. All right, so the ADA is the Americans with Disabilities Act. We went over this in chapter 4. It requires that all commercial properties be handicap accessible to people with disabilities. That includes for the employees as well as the customers. So, Title III of the ADA prohibits discrimination on commercial properties, requiring them to be handicap accessible. Now, if you have new construction, it's easy to create the building and have it handicap accessible from the get go. So, what about existing structures that are out there? Are they required to be modified and become handicap accessible? Well, what is the requirement of the ADA? Well, their requirement is all new construction must be handicap accessible. But for existing structures, the ADA recommends reasonably achievable accommodations. That's probably a term you'll hear on exams too. Uh, Reasonably achievable accommodations to provide full and equal access to the facilities and services. Now, what is reasonably achievable accommodations? Well, that means with little cost without massive retrofitting and remodeling. Okay. Now, that could also be subjective too. Keep that in mind. So they say it's useful to consult ADA experts and architectural designers. Some examples of reasonably achievable accommodations may be lowering wall-mounted payphones, if you could still find them around, lowering the water fountains, or installing a cup dispenser next to a water fountain as a workaround instead of lowering it. Just make sure you don't run out of cups. Otherwise, some ambulance chaser attorney is going to be waiting for somebody to roll up in a wheelchair so that they could sue. Yeah, because the water's not available to them because they didn't lower the water fountain. Changing the directions that doors open, adding ramping, changing door handles to push bars, installing auditory signals and braille buttons in elevators, or making handicap parking spaces available for people with disabilities where appropriate. So this is what you need to know for exams: reasonable, achievable accommodations and what that means. So let's do the highlights now, page 242 and 243. About the Americans with Disabilities Act. What type of properties does it affect? Commercial. And what are their recommendations for making existing structures handicap accessible? Okay.
So this is for commercial only. Um,
Yeah. Yes.
I'll share a personal experience. I mean, my child is disabled, and we have a parking in between the cars, right? Mid parking, and in that parking lane we have a corner parking also, which has no number written on it. So
Uh-huh.
we requested
A
the
sign
leasing
or
office. Yeah,
yeah.
yeah. There is no sign on it because it's a normal apartment. It's not a special apartment. I mean ADA. So we requested them that if they can, you know,
Assign that one to you.
put a sign, yeah. So
I
they
would say,
denied.
hold on a second. I would suggest not just putting a sign there, but assigning it to you to put a
So
number on
we
it.
requested in both the cases. We said either you shift the parking here or
Well,
you
hold on a
just
second.
put a disabled sign.
uh, don't just put disabled sign. Have them assign it to you, because
They denied.
if they just put a disabled sign on it, the disabled anybody with a handicap plates or a card can park there.
But
It's
they
not.
denied in both the cases. They said nothing is possible.
Why?
I don't know. My husband, I asked my husband to talk to
They have
them.
assigned parking there with space numbers.
Not in my lot, but few.
Oh,
I mean, few.
oh, I thought you said that. Okay, I thought that
Um,
there was some there with space numbers, but that one didn't have a number.
no,
Okay,
that's blank.
so none of them have numbers on them, right?
No, no.
Okay. Yeah, because then they'd have to let every tenant know that there's assigned spacing now, and usually in the leases that stuff would be addressed.
So in
Uh,
my lane, I guess there are two disabled signs or one, just
uh-huh.
one. But not at my not near my apartment. So we requested if they can do it because my son is 11, so it's difficult to, get him out of the car. And
You
so
know what?
they denied in both the cases.
Send them a letter again and ask for this as a reasonable accommodation for the handicap of your for your son being handicapped as a tenant there. You're
No,
asking,
we did.
hold on a second. Yeah, but it's how did you ask? You know, try asking as a reasonable accommodation. Because remember, landlords are required to provide reasonable, even in residential properties, landlords are required to provide reasonable accommodations to the facilities and services. And if you can't get out of the car because you're parked too close to other people and whatnot, um, that causes a problem. So write that in the letter that there there's an issue here because in the normal parking spots we cannot fully enjoy the premises to be able to get out of the car here. We're just asking for a reasonable accommodations for the handicap of my son, um, to have a parking spot that we could get him out of the car. If you could assign this parking spot to us, you know, it's not going to affect other tenants. We're just asking you to assign this parking spot to us. You could put a handicap sign or spray paint it on the ground, and say this is an assigned spot.
Mm,
Okay, just this
okay.
one spot can be assigned. You don't
Mm.
have to put assignments on all the spots. Just this one for us. You know, um, they're required to have some handicap parking. Do they have handicap parking there?
We have, I mean, in my lane, I think there are two handicaps parking. Yeah, there are two, but they're always full.
They're always
So
full.
that is why I asked them that this is a vacant lot. Just place my sign, give it to me. I mean,
Yeah,
or
yeah,
just put a disabled sign on
yeah,
that. They
yeah. But
denied in both the cases. So
yeah,
so it was all verbal. So I'll put it in writing and
yeah,
check with
yeah.
them again.
Put it in writing. Yeah, don't do verbal. Do everything in writing. So
Mm,
you send them official letter in writing asking for a reasonable accommodation, to have a handicap parking spot assigned to your apartment for your son to be able to get out of that spot. Let them know there's only two spots in this entire lot. And they're usually taken. I'm just asking for to have one handicap spot assigned to our apartment. So you don't have to list it as a handicap spot, but just list it as an
assign it to
assigned
me.
spot to this unit.
Mm,
You know,
okay.
um, as a reasonable accommodations so that we can fully enjoy the premises despite having a handicap,
Mm, okay.
and see what they say then. Because when you start using certain wording like that, providing reasonable accommodations and such, then they start to get worried about discrimination
Mm,
against handicapped people.
mhm,
So all we're asking for is a reasonable accommodation, which you've previously denied in my verbal communications. I just want to get it in writing now. Now they're going
okay.
to think about why does she want to get it in writing?
Okay.
Okay, so it might light a little fire under their butts, and then
Mm-hmm.
again, it may not. I don't know. You may
Mm-hmm.
you could ask an attorney for a recommendation on it, or maybe even AI. AI, even though it doesn't give legal advice, you could
Mm-hmm.
get some good legal advice out of AI
Mm,
these days,
yeah.
even though it says that they specifically don't. So you could ask AI, how can I ask my landlord in a complex with so many units, uh, to have an assigned parking spot, which makes it easier for me to get my handicapped son in and out of the car. And maybe it'll think about it, give you several different scenarios and such. It's a
Mm,
pretty good idea to. It's hey, AI is a useful tool. Even though it'll tell you, talk to an attorney for legal advice, but none of this should be construed as legal advice. But And then they'll give you a big legal
Mm.
jargon.
Mhm.
Okay.
Yeah. Thank
Uh,
you.
welcome. Yeah. You could even throw in there how to ask for a, um, you know, an accommodation, the reasonable accommodation for the handicap. Okay. Because remember, in leases, the what the heck is it? In the Attorney General's memorandum, there is an issue there that it brings up making modifications to a premises for it to be handicap accessible, right? You should also include a copy of that printed out with your letter and highlight that portion. All right. But this is not legal advice. You should consult with your own attorney because I am not an attorney. So, my disclosure, okay? There you go. All right. Everybody got these highlights, these notes? We're all good here? All right. All right. So, service animals. We remember service animals. We spoke about them a little bit in chapter 4 as well, right? Service animals means a dog, but in some instances, it could mean a miniature horse. Okay. Service animals perform tasks, but you could also have, let me see, perform tasks for the benefit of the individual with a disability, including physical, sensory, psychiatric, intellectual, and mental disabilities. Tasks performed can include, among other things, pulling a wheelchair, receiving dropped items, or retrieving dropped items, alerting a person to a sound, like a doorbell that they may not notice, reminding a person to take medication or pressing an elevator button for them. Um, when a person with a service animal enters in a public facility or a place of public accommodation, the person cannot be asked about what the nature of the extent of their disability. Only two questions can be asked. Is the animal required because of a disability? And what work or task has the animal been trained to perform? And an additional notice, their additional note, uh, these animals, these service animals, they must be in the owner's control at all times with a leash, unless the the nature of the disability were for it would interfere with them performing their tasks having the leash. Okay, so there we go. ADA, reasonable, achievable accommodations. These are just some examples that I've already read off to you. It's just the picture examples, adding grab bars to public restroom stalls, making sure there's enough room for a wheelchair to turn around. You know, I've I've consulted with ADA experts before when trying to rent a building. The city inspector said, "Oh, you got to put in a ramp here because the entrance to the building uh, there was about an inch and a half lip, maybe 2 inches from the door sill to the ground." And he's like, "Oh, anything over 3/4 of an inch, requires a ramp." And I was like, "A ramp?" "Yeah, with the grab bars and everything." I was like, "Can I just cut a block of wood at an angle and stick it there? And you got no more 3 inch, And he's like, "No, it needs to be a ramp." I'm like, "Really?" So I got to spend $5,000 on a ramp for 3/4 of an inch. Oh, okay, that makes a lot of sense. Um, Now we get into the building. He goes to the bathrooms. He's like, "Yeah, these bathrooms, they need to be handicap accessible. You got to add grab bars, and it needs to be widened so that if wheelchair, it could accommodate a wheelchair." And I was like, "Can you explain something to me? How's the wheelchair supposed to get to the bathroom? Look at the width of the hallway. The width of the hallway wouldn't accommodate a wheelchair getting to the bathroom, but I got to have a bathroom that accommodates a wheelchair, but the wheelchair can't get to the bathroom." He's like, "Well, these are the rules." Well, the rules are stupid. They don't use any common sense. You know, reasonable, achievable accommodations, I thought it was. Well, yeah, it requires you to be in the bathroom, be handicap accessible, even though they can't get to the bathroom. because of the hallway not being wide enough. It's like, all right. Needless to say, I did not lease that building or purchase it. Um, lowering public telephones, permitting guide dogs to accompany customers, providing menus and real estate listings in large print or braille format, providing doors with automatic opening mechanisms, installing an intercom so customers can contact the second floor business in a building without an elevator, shopping assistance, things of that nature, providing ramping. Okay, rental referral agencies. We went over these at the end of chapter 1. Rental referral agencies when a real estate company specializes in only dealing with rental properties. They come to agreements with large apartment complex owners that if they find them a tenant, that they agree to pay them a referral fee. Okay. Now, because these apartment complexes usually have their own rental agents, um, it is possible that they could rent them out on their own. So we need to check if we get one of these listings. If we advertise it, we need to check every day with the building owner to see if one of those units are still available. And if it's an in-house listing only and it's not advertised otherwise publicly, we need to call the owner every 3 days to make sure that one of those units are still available. And of course, anytime we get advance fees of more than $25, that money needs to be put in escrow. Now, why would we do that? So the contract must specify things like services to be performed, fees charged, date and term of the contract, and refund policy. The service should charge no more than $25 until the tenant actually secures an apartment listed with the broker. If prospective tenants are charged an advance fee of more than $25, regulations require you deposit those funds into the escrow account. And no property may be offered without the landlord's consent, of course. You can't be looking for renters for a landlord if they didn't hire you, right? All right. So get that stuff down. You got those links, these things highlighted, these notes. Rent control. This is a double-edged sword. Rent control was used to, these are laws set by each municipality. Not all municipalities have rent control. These are laws put into place to prevent abusive landlords from taking advantage of tenants. It controls raising rents, charging late fees, evictions, etc. Licensees should be careful when showing rental properties for sale to investors. They should use caution before telling them the rents are below market rates and can be raised. Because they may not be able to be raised because they're in a rent control area. You better make sure first. If the municipality has rent control, they may not be able to. So before you go doing any of that puffing when trying to sell these properties, it's a good idea to find out if they got rent control in the area. Yeah. So that's good to know, because if a property has rent, if a property is in a municipality that has rent control, the landlord, that may be why that building owner is selling to begin with. Maybe they're not able to raise the rents to keep up with the cost of living and maintaining those properties. So that's why they're selling it, because they can't raise the rents and keep up with them for the maintenance and such. So these are rules set by each municipality if they have rent control. And although rent control clearly benefits tenants, many argue that in the long run it can hurt them because it could discourage investors from putting up rental housing and could cause hardships to landlords who cannot bring rents up to fair market value, encouraging them to let the buildings deteriorate and eventually be abandoned. But first, they'll try to sell it first and pawn it off on somebody else, right? So make sure that you don't go putting, oh, wow, look at this rental property. Price is really good on this. Wow. Oh, look how low the rents are. You could always jack the rents up over here. Those are way below market rents. Be careful. Check for rent control. If they got rent control, that's why you can't. Maybe they're forced to have them at that super low rate. And because they're that low, it doesn't make sense to buy that building because you'll probably be putting more money into it than you're getting out of it. And that's why the landlords are looking to get out of it. So, condo conversions and evictions. Who cannot be evicted from a condominium conversion? Well, those age 62 and older, or those with certain disabilities. They must live there for at least 2 years before the conversion began, and their income is no more than 3 times their county's per capita, or in any case, no more than $50,000 per year. If they meet all of those requirements, they can remain as tenants for the next 40 years, and you can't evict them just so that you could deed the place and sell it. So here's where you could highlight that on page 245. Who cannot be evicted from a condominium conversion? A landlord may not evict a tenant without a court ruling. True, because that's what eviction is. It's revoking their rights. In cases of hardship, the court may allow a tenant as long as 6 months to find other accommodations. Oh, and they lay it on the landlord. You got six. They could give you up to 6 months if you get a bleeding heart judge there. You get people, they know how to play the system too. I've dealt with this before, where you've had this tenant, this young pregnant woman. She, or not pregnant, she has a young child, um, and she knows how to play the system. She moved into a new apartment with the intent of not paying any rent. You get the tenant in there now, and now she's already not paying rent. She's requiring the landlord to get her to evict her. Then she goes to court with her baby and she's pleading, "Oh, you can't put me on the street. We have nowhere to go." And a judge could give her up to 6 months to find other accommodations. But apparently, this one girl that I had an instance with, apparently, she had a history of doing this. Like the judge knew her. The judge knew her. The court clerk, they knew her, because landlords have been evicting her for the longest time, but they still keep giving her more and more time. And basically, it falls on the landlords. So you still need to pay your mortgage. You still need to pay your insurance. You still need to pay your taxes. And now you got half a year, some deadbeat that's there for a half a year, uh, you know, living in your property, never had the intention of ever paying you. So they were looking to get one over on you from the beginning. That's not every tenant, but there are tenants out there that are like that. So we got to be aware of that. Okay. All right. So those are the tenants that cannot be evicted from condo conversions. We highlighted that on page 245. Now, how about this one? Constructive eviction. You ever hear that? Sounds like construction, constructive. These are actions taken by the tenant to legally terminate their lease early. Remember, if you terminate your lease early, you're in breach of contract. But here's a way you could do it and not be in breach of contract. If the landlord fails to provide basic services or make essential repairs when there are uninhabitable conditions. Uninhabitable conditions are not like you want them to remodel the kitchen or repaint. Okay, that's not uninhabitable conditions. Okay, the tenant must notify the landlord, number one, that there's a problem, and then if they don't fix it, they could vacate by moving out and then stop paying rent and notify the landlord you're terminating the lease early due to constructive eviction. Always get legal advice from an attorney before taking any actions. Landlords may return or must return all security deposits to those tenants then. Here's an example where I had a tenant that actually used this. The landlord was my client too. I had the listing, and this was my first listing with him, and he owned a bunch of properties, but I rented out the main house. Is basically a house that was grandfathered as a two family, having the basement unit legal because it was grandfathered. So it's basically a one family house. So the first and second floors were one family, and I rented that out. And then I got a tenant for the basement unit apartment, which was a young pregnant girl or young mother. Sorry, young single mother. And they had a separate entrance there from the outside, but they're required to have two separate entrances when there's a rental. So the only way this remained as a legal rental is if the stairs that went into the first floor apartment were left, the door was left unlocked, you know. But neither tenant would want that. So it was just unlocked for the inspections. But when people are living there, it's always locked. But either way, there was an issue with the tenant. She liked it was good enough price for her, and she's a young single mom, so it was doable. A couple months later, she gives me a call, and she said, "Victor, what do I do?" Usually, the landlord is great at responding to me, but he doesn't like taking phone calls, only by text message or emails. But he's ignoring me now, and I can't. He's like, "I can't live like this." I said, "Well, what's the problem?" Every time the tenants upstairs flush the toilet, it comes out in my tub. I first noticed this when I was bathing my newborn baby. You know how you put the newborn babies in that plastic, the little plastic tubs inside the tub, you know? So she was bathing her baby, and then urine and feces are coming out into the tub. She's like, "This is disgusting. If I'm taking a shower, if I'm bathing my baby," she's like, "This is disgusting. This is uninhabitable." And I said, "I agree with you. That is uninhabitable. Have you tried reaching out to the landlord?" "Yeah, but he's ignoring me." "Can you document that you've been trying to reach out to him?" She said, "Yes." I said, "Then this is what you do. You go down to the city," because this was Edison. I said, "You go down to the city, and the health department deals with the rentals in Edison. So you need to file a complaint with the health department about this guy." Apparently, the two girls that were down there at the health department, uh, they're like having a conversation with each other when she was filing the complaint. That she was telling me about it. She's like, there was the two girls. One girl was sitting there, the other was looking in the cabinet, looking up who owns it, and she saw, and the other girl was like, "Guess who it is?" And the other girl was like, "No." "Yep, it's Chester." And they're like, "Ah, yeah, that guy doesn't fix anything until we force him to. We have to give him fines and stuff. Otherwise, he just slaps paint on stuff, makes it look new, and then something breaks. We have to force him before he'll do anything if anything is major." So they said, "Okay, we'll get somebody out there." And I was like, "Okay." So she filed the complaint with them, and then I said, "Is there anybody you could move in with for now, like a friend or family member that you could move in with while we look for another unit for you, another place to move to?" And she's like, "Yeah, I got a girlfriend I could move in with." I was like, "Okay, then you do this. Move all your stuff out before you stop paying rent. Then stop paying rent and send a letter to the landlord notifying him you want to terminate your lease early due to constructive eviction and that you want all your security deposit back sent to you there." Okay. Um, I said, "But before you do this, let me give you one of my attorneys. I got an attorney's number. I want you to call him and just ask him that to confirm that I gave you the right advice to do things in the right order, because I don't want to jam you up. This is legal advice, and I'm not an attorney, so I just want to make sure I don't jam you up by giving you the wrong advice here. So make sure you talk to him first." So she did. She confirmed it. I gave her the right advice, told her what to do, and she did that. I got her out, found her, and then started looking for a new place for her. But as soon as she got out, she sent that letter to him. Guess who I got a call from? Chester. Okay. Now, he was yelling and screaming. By the way, he was not aware that I was in communication with her, but he was yelling and screaming at me that he wanted his commission back, that he paid me a commission for me getting him a tenant that would be there for a year. And she wasn't there for the full year. She moved out early. And I was like, well, I know. You know how I know? Because she contacted me. I was like, that's pretty messed up how you treated her. I was like, I'm not going to be taking your listings and trying to get you tenants, uh, good tenants, um, just so, and then you're going to be treating them like a slumlord. I said, I'm not going to be doing that. I don't need your business that badly. I'm not going to get a bad reputation because I work for a slumlord. I was like, why did you treat her like that? I'm not getting any answers from him. He's just like, I paid you a commission for a tenant that was going to live there for a full year. And I was like, all right, well, I know why she moved out. I was like, I think that was a scumbag move of what you did to her. She got, feces and urine coming into the tub. I was like, would you want to live like that? I was like, that's disgusting. I was like, and now what? You want me to give you the commission back or get you another tenant in there? No, you got to fix that place. I was like, I'm not going to be doing that. And he's like, I said, and plus, I earned my commission. When did I earn my commission, guys? When I produced a ready, willing, and able tenant. We had the city inspections done, and the lease inception date came. She got the keys. He got the money. Landlord tenant issue now. I did my job, right? So don't come after me, yelling at me, getting all huffy and puffy with me. I was like, I did my job. I earned my commission. So don't be telling me that you're going to be suing me for anything because I did my job. Because you can't keep your tenants because you're acting like a slumlord, that's on you. You know, I'm going to, like, he's yelling how he's going to sue me. I just hung up on him. By the way, he was an attorney. So he's like trying to throw his weight around. As an attorney, you should know better, you know? So screw that guy. um,
So for future, do you guys report such kind of landlords or people or
I
property
had
that
her
they
do it.
think
I had
aware?
her do it.
Her do it. Okay, okay.
Yeah. She reported him to the health department because the health department, whoever controls rentals in whatever town it is. In Edison, the rentals are managed by the health department. So I told her to go file a complaint with the health department there. And they dealt with it. They knew the guy by name. They knew by first name. They knew who he was. The girls were joking about it.
So
Uh,
how will a new tenant will know about that property or that landlord?
well,
He
you
will
could
be
go.
stuck to.
All you could do is go there and inspect the unit and see if it meets your requirements, if you like the way that it is before you're there. Maybe flush the toilet, run the water a little bit. But I mean, in this instance, what exactly happened here? Because she didn't have this problem when she moved in. It's a couple months later. So what
Mhm.
happened was the sewer pipe, the sewer main that's on the house goes through the whole house and then it goes out towards the street. But before it got to the street, it collapsed. I think from
Hmm.
old roots or from an old tree that was once there or whatever. Anyway, it collapsed. So every time they flushed the toilet, it would come hit that blockage and then back up to the lowest point, which is the tub in the basement. So and then it would slowly drain out. Okay, so he needed to spend a couple $1,000s to get this piece of sewer pipe replaced on his property. It was like $2,000 repair or $2,500 repair. He didn't want to spend the money. So that's what that was about. So all you can do is try to maybe talk to the other tenants when you're there. Maybe ask about the landlord. Maybe run through the systems, flush the toilets, look around for things. But in this instance, it wasn't anything that happened with her toilet when she flushed it. It was when they flushed it. It'd go out to there and then back up. So, but she could still do that. I guess if she flushed her toilet, it goes out the same sewer main. If there's a backup, it would come back up. So run the water, flush the toilet before you go moving into a place. Make sure, you know, uh, stuff works. That's all you could really do. Now, Constructive eviction is an action taken by the tenant when a landlord fails to make necessary repairs. Uh, Actual eviction or suit for possession, also known as actual eviction. This is the normal eviction that usually occurs where the landlord takes actions against the tenant for violating the lease terms in some way. Okay. So eviction is the process of the court revoking those tenants' rights when the tenant breaches the lease. Landlord files for what's known as a summary or dispossess proceeding to dispossess them from the property, to get the property back. A landlord must provide a notice to quit to the tenant before filing for eviction if they're violating the terms of the lease. The only exception that doesn't require a landlord to serve tenant a notice to quit is for non-payment of rent, in which all they need to do is file for eviction. They don't need to serve any notices. You know you didn't pay the rent, you got to go. So the landlord could immediately go and file for eviction without serving any notice to the tenant. They know they didn't pay the rent. So now, how much notice is needed for the landlord to provide to the tenant before filing for lease evictions for other reasons? Well, on another slide I'm going to have here, the landlord's guide for giving tenant notice to quit before filing for eviction. Yeah, I know that's wordy, but that's the only explanation I could come up with. If you got a shorter one, then that's great. Write it there above page 245 and 246 where that guide is. All right, we'll get to that in just a minute. In the meantime, here's where you could do the highlights and the notes for constructive eviction and suit for possession, which is actual eviction. We'll be taking our lunch break in a moment after we get these highlights down, and then we get to that guide. I'll just leave it up on the screen for you guys to take the notes during or after lunch. Okay. So constructive eviction, this is the action taken by a tenant to legally terminate the lease early due to uninhabitable conditions. That's constructive eviction. Now, sometimes the landlord will purposefully not do repairs to get the tenant to self-evict because it's a lot easier than him trying to get them evicted so that he could get a tenant to pay more money as well. That's another way that a landlord can illegally try to remove a tenant through constructive eviction by getting them to evict themselves and terminate the lease early. Okay. There have been schemes about landlords doing that in New Jersey before, too. Okay. Everybody got these notes and highlights?
Once again, what will happen to the landlord after constructive eviction?
He could be forced to do the repairs. He could be fined if he doesn't. Tenant can sue him if they know that he's doing it for a reason to try to get them out so that he could get a different tenant in there that pays more, if they're aware of that. But if they just can't get him to do the repairing because he's cheap, they get the city to come in and force him to do it. Okay. Can I change the slide? Everybody got these highlights and notes? Okay. All right, so here are the causes for eviction. Remember, I told you what is the only reason that you could evict somebody without serving them with a notice to quit whatever lease breaking activity it is that they're doing? It's for non-payment of rent. So here are the other reasons. So over here at the top, I wrote landlord's guide for giving tenant notice to quit before they can file for eviction. Now, I got this screenshot from a previous version of this book where it was all on one page. Your version this is split across 2 pages now, to page 245 and 246. So you can write that at the top over there and highlight the very first bullet point: non-payment of rent, notice to quit need not be given before the suit is filed. All the other reasons, which you could go over, I'll leave it up on screen. You could go over during lunch if you want at all, or when you return from lunch. You could go over this and see that for different reasons, how much notice to quit is needed. In the meantime, I'm going to pause this recording. All right, so if you're going to be in property management, having a guide like this would be useful for you, because these are the rules in New Jersey as to the landlord's guide for giving tenant notice to quit before they could file for eviction for various reasons, how much notice that they need to give. So you may find this as a useful thing. So it's good to have. You don't need this for exams. For exams, you just need to know what's the only reason, what's the only cause that you could evict a tenant without prior notice, and that is non-payment of rent. They know they need to pay the rent. They should be paying the rent. So all these other reasons, though, could be helpful for you if you're involved in property management. So that little title up there can be your guide. Also, I always also mentioned shows and TV and stuff. There was a TV program called World's Worst Tenants. I don't know if you guys recall that when it was back on, when it used to be on TV. It was supposed to be scheduled for another season, but they had an issue. There was a fight between one of the members of the cast and one of the background people, I guess, in the show. So that put it off for a while, and then it just disappeared. I think they ended up selling the network. It was called Spike TV. Don't know what it is now, but you could still see these episodes online. I got the link for it right there. Some of them are funny, but it was about evictions. Eviction specialists. They work for eviction specialists, landlord tenant communication specialists. Let me put it that way, because when landlords don't want to deal with the tenants, they hire these guys. They go serve proper notice or investigate complaints by tenants and such. And it was actually a pretty good show. Here, I'll share that with you. It's called World's Worst Tenants. There's a link to it. You can watch those. You may get a kick out of watching them. There was a couple seasons of it. I think 2 seasons. Anyway, so let's now talk about types of leases. When we talk about types of lease, so far we spoke of leasehold estates, the 4 types of leasehold estates. Now we're going to talk about the different types of leases, the contracts. We have a gross lease. Now, when we talk about the leases, we're talking about payment and what's included. A gross lease, this is common in residential. You could find it in commercial, but it's more common in residential, where the tenant just makes their gross payment. They make a payment, which pays the basic rent. And the landlord's responsible for all the property charges, taxes, repairs, insurance, and the like associated with the property. In a net lease, this is common in commercial and industrial properties, also known as triple net. There's another variant of a net lease. There's a triple net, so that's expressed as NNN. All right, where the tenant pays their basic rent plus most or all of the property charges, except for the mortgage financing. And the landlord, the lessor, they may pay some of the property charges. Okay. In a percentage lease, this is common for retail properties. The tenant pays a basic rent plus a percentage of the gross sales. They may pay property costs. So basically what happens is the tenant pays the basic rent, small basic rent, and a percentage of their gross income, okay, to the landlord. This is common like in major shopping centers and such. You ever see stores in shopping centers? They're there one day, they seem like they're doing killer business. The next day they're gone. Maybe because they're selling little retail items that aren't netting a lot of money. Even though they seem very busy, they're not making enough money to satisfy the landlord's appetite of the type of income they're seeking from a tenant to occupy that space. So their lease may have a thing that says the tenant is required to pay the rent plus a certain gross amount of their income above a certain dollar figure. Um, and they may not be getting to that dollar figure, or it's not enough uh, according to the minimum that may have been specified in the lease. So the landlord may pay some or all of the property charges in this. Okay, so these are the characteristics of the types of leases. So gross lease, once again, common in residential, but may be found in some commercial. Tenant pays their fixed rent, and the landlord's responsible for the maintenance of the property, paying the taxes and the insurance, etc. In a net lease, the tenant pays rent and some of the property charges, whatever is agreed to in the lease. Now, a version of a net lease would be a triple net lease. This is very common. Also is just simply referred to as NNN, having three capital N's there. The tenant pays the rent and all property expenses, except for the debt services for the mortgage loan. The tenant even pays their share of the taxes. I have a net lease. Ooh. So in the net lease, the tenant's responsible for paying the rent and all the common area maintenance charges, could even include paying the landlord's insurance on the property and their taxes. So, for instance, I'm renting 5% of the space in the building that I'm in. So I'm responsible for 5% of the property taxes on the property, 5% of the landscaping costs, et cetera, et cetera, et cetera. Okay. Those costs common to take care of the common area elements are referred to as CAM charges. CAM is the common area maintenance charge. Every tenant got to pay their proportionate share of it. Like I just said, gave you an example. I'm renting 5% of the area of the building, so I'm responsible for 5% of all those common maintenance charges. Now, the term CAM, I don't think you see that anywhere in this book, by the way. You may want to make a notation of that somewhere. CAM charge. Okay. I'll show you a place, actually. I think I'm coming up on one of the slides where you could write it. Here, so just highlight this. In a gross lease, the tenant's obligations to pay the fixed rent, and the landlord pays the taxes, insurance, mortgage payments, and the repairs, most often used in residential rentals. Okay. Now, in a net lease, you could also write next to that triple net or NNN, common for commercial and industrial properties. Now, net lease provides that in addition to the rent, some or all the property charges are paid by the tenant. With a triple net lease, the tenant pays all the property charges except for the debt services. So here underneath that, write CAM, Common Area Maintenance Charge. That's what CAM stands for, and it's nowhere in the book, so you might as well write it in there, pencil it in, what CAM is. It's kind of like the HOA fee that a tenant would pay in a condo. You know, CAM charges for commercial property. A lot of times when they quote you what the rent is, they'll price it per square foot, and often they don't even tell you what the CAM charges are because they could vary from month to month. Now they could quote you what the average is, but you'll end up paying what the actual charges are. Now, a percentage lease provides that the rent will be based on a percentage of the gross income received by the tenant doing business in the property. So this type of lease is most commonly found in shopping malls. It's not only based on the rent. the income. It's basically an example they even give you here in the come on that they give you here. Tenant pays a fixed monthly rent of $1,200 with a further agreement that they pay an additional amount each month equivalent to 5% of all the gross sales in excess of $30,000. Okay, well, hopefully that tenant is making in excess of $30,000 a month, because if they're not, then the landlord's not getting any additional money. So the landlord could put an additional requirement in there that they need to gross at least X amount of dollars. So here's how you actually calculate the rents on a triple net lease. If you're quoted a $20 per square foot and you ask them and they tell you that the CAM is estimated at about $5 a square foot, calculate them separately, because CAM charges are going to be the actual charges. First, we want to find out what our actual rent payment is going to be. So if we're renting 2,000 square feet of space, take 2,000 times it by 20 dollars per square foot. That's $40,000, but that's not monthly. That's annually. So divided by 12, and that's $3,333.33 in monthly rent. Now we calculate separately to estimate the CAM charges at $5 a square foot, comes out to another $10,000 a year, or $833.33 a month. That's a lot of extra money there too. You need to really factor that in. But here, we have a basic idea of what our rent is. We could see, is that rent too high or not? And then we look at the CAM charges, because could CAM include heat, hot water, things of that nature? Maybe. You got to see whatever the lease agreement says. They may get separate bills for that too. Electric, whatever. So if you were to add both of these up, you'll see your total rent comes out to a much higher figure than $3,300. It's $4,166. That's a lot of money. But now the tenant can at least see what their true rental figure is going to be, and that's how you do it in commercial real estate. All right, so here's just my explanations of the percentage lease again. And then underneath that, we have other types of leases. These are more along the lines of provisions added for longer term leases. So variable leases are provisions added to long-term leases with built-in predefined escalations of the rent, or possibly even CAM charges. Now, you could either predefine them or you could tie them into a cost of living index. It says that, okay, well, the second Sunday in January of the new year, whatever the cozy index says, that's the percentage that the as published in the New York Times will be how much your rent goes up in your lease. Okay. They're tying it into a cost of living index, possibly. Okay. You don't see that a whole lot, but that does happen. Now, ground
So in
leases,
this case,
yeah.
uh, if it is a small fixed rent and the shop is not earning profit, then it is, I mean, negative for the tenant also and the landlord also, right?
Well, no, in this right here,
Percentage, no, in percentage lease.
in a
In
percentage
the
lease.
second line, it says
Yeah.
tenant could pay a small fixed rent. So in that case, if the shop is not earning profit, then both the parties will be in loss. Then
Well,
what's the point of?
the landlord doesn't get any additional money to that small fixed rent.
Okay.
So if the tenant, you know, keeps operating at a loss or keeps operating at an income that's a profit but less than the amount that the landlord requires as a minimum, um, it could be a reason for them to terminate the lease. So they get another tenant in there that knows how to generate higher income levels. That's why you would see those stores that seem busy but they're not making a lot of money selling those little widgets, whatever their product is, then the landlord will get someone that sells widgets that are more profitable, you know, and that way they make more money on their space. All right. So a ground leases are triple net leases. What is a ground lease? A ground lease is a type of lease where the tenant rents the raw land and then they erect a building on that land. So therefore, that's going to raise the taxes, right? It's also going to be more maintenance. Now you got to worry about snow removal and all that stuff. Tenant's responsible for all of that. It's their improvement. They're responsible for maintaining it and the additional taxes that come because of it. So in a ground lease, it is a triple net lease. The tenant is responsible for paying a rent for the land, and they erect a building, and they're required for all the maintenance and additional expenses that are required to maintain that building. Okay. They're usually long-term leases. 50 to 1,000 years is not uncommon. 1,000 years. Our country's only celebrating its 250th anniversary this year. Okay. In 2026, we're celebrating our 250th anniversary. So what's up with this 1,000 year stuff? Well, if you're going to be erecting a building, like some of these ones, the Empire State Building, okay, MetLife, Chrysler, World Trade Centers, the land is owned by the Port Authority. So you better get a long enough lease to, if you're going to be constructing one of those buildings there, you better get a long enough lease that it's going to pay for the construction of such buildings and to turn profits. These aren't, people don't live to be this long, but maybe a corporation can, or one of these funds, funds that may own the buildings, as investments. They may, and they can live on forever, right? So that's why they have these long-term types of leases to be profitable. It's going to take a couple of years before that you start turning a profit on constructing a building like the Empire State Building. Right? All right. Now, don't confuse a ground lease with a land contract. The land contract is the type of seller financing where the tenant does not turn over the deed to the owner, to the buyer, until the full amount is paid off. Okay. The ground lease is entirely different. That's where you're renting the land and you're constructing a building on. Okay. And then we have mineral leases, sometimes referred to as subsurface rights, or oil and gas leases, or mineral leases, where the landlord rents the land to somebody and they get a percentage. It's kind of like a percentage lease. They get a percentage of the profits from whatever is extracted out of the ground that's profitable, right? Gold, silver, oil, gas, what have you. So I said, take a look at those TV shows like Alaskan Gold Rush. You could see they always get nervous. Oh, the landlord's going to be paying us a visit. They stop all production of digging up the dirt from the ground, and they run everything that they have dug up so far through the sluice box so that they can try to see how much gold they have, see if they're meeting the landlord's minimum requirement there, at least. All right. So here's now just where we would write it in the book. Variable leases, this talks about provisions added to long-term leases. Ground lease is also a triple net lease. And oil and gas leases, these are also known as mineral leases or subsurface rights. Okay. Look at that. Imagine constructing this building on land you don't even own. Putting all that money into constructing a building like this on the land you do not own. You better get a long enough lease that makes it worth it, right? Wow. That's some icon there. A global icon used to be the tallest building in the world at one time. Ever been?
So yeah, so this Eiffel Tower was also in news that its lease is expired, and we will remove it from there. It's an eyesore to that area. Something was that in the news a few
Who
days
said
back.
that? Yeah,
Yeah,
that's the Eiffel Tower is an iconic structure over
yeah.
there. I highly doubt that it's going to be removed. So, what are you saying that the Eiffel Tower was a type of ground lease
Yes, I think so. I think that was in the news. If you'll Google, if
recently? Yeah,
yeah, two,
let's
three
take a
months
look.
back, I guess.
Yeah, let's take a look. I'll do a little search
Research.
on here. Oh, what is it? The was the Eiffel Tower uh, built on a ground lease. Hope I spelled Eiffel right. If not, it'll figure it out. It says no, the Eiffel Tower was not built on a ground lease. It was built on land owned by the city of Paris. Yeah, but that's kind of like a
No,
ground.
it says Eiffel
Okay,
Tower was originally built with temporary 20-year ground
yeah.
lease permit for 89 World Fair.
Yeah, it says Gustave Eiffel only received a temporary operating concession, not a lease of the land itself. So that's why it's not a ground lease. Um, the Eiffel Tower was built on Champ de Mars, a large open area that had already been returned to the city of Paris before construction began. The land was never leased to Gustave Eiffel or his company. Instead, in 1887, a convention was signed between Gustave Eiffel and the French national government in the city of Paris. The agreement gave Eiffel 20-year concession to build a tower at his own expense with a partial subsidy and operate it commercially until December 31st, 1909. Ownership of the tower itself automatically transferred to the city of Paris on January 1st, 1910. Okay, so Paris owns it now, no longer owned by the Eiffel or his family
Yeah. So
or
these
his
were the
corporation.
rumors circulating in
Yeah.
2025 that tower will be demolished in 2026 due
Well,
to lease expiration are false.
it's up to Paris because Paris is who owns it. It's the government that owns it now. See, so Eiffel never owned the land, and the arrangement was not a ground lease. It was a temporary operating concession. Okay, so he wasn't paying anything then, I guess, because it was never leased. Let me see. Um, there is a persistent myth that the tower was built on a 20-year lease. In reality, the 20-year term applied only to Eiffel's right to operate the tower, not to the land. City of Paris retained full ownership of the land and the structure from the beginning. Eiffel's concession allowed him to recoup his investment through ticket sales and commercial use. So that's what the thing was. This is why some modern articles incorrectly refer to an expiring lease, but historically and legally, no ground lease ever existed. Today, the city of Paris owns the Eiffel Tower. It's managed by SETI, the Société Exploitation de la Tour Eiffel, a company that is 99% owned by the city. The tower remains one of the most protected monuments in France, so I doubt they're going to be tearing it down anytime soon, right? Let me ask: are there any plans to demolish
No,
the
these are rumors they're saying now.
Eiffel Tower? So no, yeah. So you already checked it. Yeah, it says nah, no plans to demolish it. All recent
So,
claims of
so
demolishing it were
I'm reading a news right now. It says Eiffel Towers to be demolished in 1 year as lease ends amid rising eyesore complaints.
eyesore
I was like,
complaints. Oh
it's
my God.
eyesore.
It's the the Eiffel Tower is an icon. The Parisians are proud of it. It's yeah. You know that that's BS, fake news written as clickbait by somebody. It could be people that it could even be by people that hate the French. That write these articles. It could be just by clickbait, people just trying to make money, what have you. Yeah. Yeah, but right off the bat, it's wrong because there was no lease to begin with, so it's false. So we could find that out simply just because of that.
So all these buildings, those are all iconic buildings of New York. Do you think these will be demolished? Yeah, I mean, in 50 years or maybe 100 years?
If
No?
they're not maintained, maybe,
Yeah.
perhaps. I don't
Hmm.
see the Empire State Building. I mean, the whole state was pretty much named after the building now. The Empire State Building. It's now known as the Empire State. Hmm. I don't know. Was it the Empire State first or before or after the building? Another interesting question. Was New York named the Empire State before or after the building's construction? Constructed. After the building was constructed. There we go. Let's see. What does it say? Oh, New York was already named the Empire State before the building was constructed. It was nicknamed that in the 1800s. Okay, there you go. So, no, not because of the building, but wow, look at that building. It was built during the Great Depression to give a lot of jobs to people that were hurting and needed jobs at the time. And then you had the hustling, bustling, after that, what was it? In the 1920s, I think, towards the end of the 1920s was the end of the Great Depression. Yeah, a lot of people have owned this building too. A lot of it is not owned by individuals, but owned by uh, these funds. These investment funds and such. At one point, even Donald Trump owned the Empire State Building. He was a part owner with some Chinese billionaire or something. Um, and he only became a part owner in it because he thought that he could negotiate with the city of New York to get them to sell him the land that it sat on. If he got that, its value would skyrocket. But he was unable to negotiate that, so he bailed out and sold his interest. He said, "Yeah, there's nothing for me here." Okay, but it was a good idea. I mean, hey, try to negotiate the purchase of the land underneath it. That would immediately multiply your wealth. Yeah, not a bad idea. All right, so what are the primary functions of a property manager? Well, it's to maintain or increase the value of the property while generating income as an agent for the owner. All right, so as a property manager, that's your job. If you look at the grander scheme of things, a lot of people, I ask them before we go into this, I ask, what is the primary function of a property manager? They're like, oh, to get tenants, to remove the snow, to clean up the garbage, to maintain the building. I'm like, yeah. You're looking too closely. Step back, take the 5,000-foot view for a second. If you were to take that 5,000-foot view, all of that is just part of property maintenance. So it's maintaining or improving the value of the property as an agent of the owner while generating income for them. Okay. It's all about the income. It's all about the money, right? So sure, their job is to do things like secure suitable tenants, collect rents, care for the premises, budget and control expenses, hire and supervise employees versus independent contractors to do work for the property owner, keep proper accounts, and make periodic reports back to the owner. Property manager could be a major function. Are you familiar with the H Mart over there in Edison? Is that Edison or Highland Park? It's the border there by, I think it's still Edison, just before Highland Park. You have the H Mart shopping center. That all used to be one building that was set way back. It was all parking lot, and then there was one building set way back at the end, and it was kind of dilapidated. Like the um, property managers had a hard time fully renting it out. The the roof kind of leaked in some places. The glass was so old and scratched up you couldn't see inside the windows, let alone while driving by. Um, Parking lot was all cracked up and full of potholes and everything. And then you saw when a new manager took over there, because immediately they suggested making improvements and the owner agreed to it, and they replaced the roofs. They replaced the roof of the entire structure, um, because there was only a couple of stores in there. There was like an Indian bank, there was the Chinese food place, a massage parlor, and the H Mart supermarket or whatever was there, and the rest of the units were empty. They for years they were trying to rent them out and they couldn't, because it was all banged up and old and beat up looking. Wasn't maintained very well. But once they started doing this, then they changed the look of the facade to a more modern stone look. They repaved the parking lot. They put in nice looking shrubs and bushes. And towards the end, by the entrance, they put in a nice modern looking sign. Okay. They've done since then, they fully rented it. Then they built, they had a tenant build another building by giving them a ground lease for a pad site, and that worked pretty good. So they had somebody else do another pad site. So all of those buildings there, they built quite a few buildings there now since. There are many, many, many buildings on that property now, all the way up to the front towards the street. They really built the hell out of it. And the best part is it didn't cost the landlord a penny. They're doing ground leases to the tenants. You know, any of those tenants move out or that ground lease expires and they don't renew it, then it's the landlord's now, and they can rent it out to whoever they want, right? They're not taking the building with them. So, yeah, that's the way. I don't know if we got a way back machine for Google, but to see where the H Mart is, uh, let me see. The
I think there are a
Google.
lot of restaurants now
There's a
at that
lot of stuff
place.
there. Yeah.
Yeah.
So I mean, here if we just go here. We put in Edison, New Jersey, H Mart Shopping Center. Okay. If we were to look that up now, all right. What is this? This is the way. Well, that was even after they modernized it already. Let me see if we can find some pictures there of that H Mart Shopping Center, which they call Festival Plaza Shops. So what they rename H Mart. Okay, you got the store called H Mart. So that used to be the only anchor there. So now it's actually called Festival Plaza. It may have always been called that. I don't know. And then there was just let me see if we can pull up some images, or even better, maps. I guess I got to pull it up by looking here. Come on. Why are we not opening? Directions, maybe? Oh, there we go. What's this? Store. I don't know why Google's taking a while to respond here. There we go. So you can see this is that H Mart shopping center or festival shopping center. The only anchor store was always that H Mart store there. Looks like they got a bank here. They got all kinds of restaurants here. But this used to be the only part was like from here on down to here. And most of the stores were not open or not fully leased. You had the H Mart anchor, and like I said, there was like an Indian bank, a Chinese buffet, uh, a massage parlor, and I think that was pretty much it. But over the years, look, now we got these buildings over here, and well, even over here it doesn't show all these There's a bunch of buildings that were constructed in the front now. Let's see if we go out here, the edge of the property. Okay, we're driving around the back of it, the perimeter. Still in their parking lot. Let's get over here. All right. This shows that one side building over here. It's another side mall with doctors and dentist office. It seems like it wraps all the way around. However, if you were to drive over here, all this grass here, this is all buildings out here now. See that there's the anchor store? I don't know why Google's not showing that here. Must have been a while since they drove by, but on this side, there's all buildings right up to the street. Yeah. So you don't see any of that here. Wonder why. Let's see. This is the last time it was put out in the parking lot. So let's go over here. All right, now we can see the modern buildings when we go out to the street. You can see it was being constructed here. You got the construction fences up still. So you can see now how much they built it up. This was all that grassy area, all built up right now. All those buildings. See, there's the H Mart thing. Buildings go right up to the edge of the street, and there's another building right over here where that other grassy plain was. And these are all ground leases. These are all ground leases. And I'm sure if they have more grass area over here, that's going to get built up some more. No, it's not. That's just the parking lot. So that's how much it built up over the years. You could see the before and after right from even from Google, the last time that they actually drove in the parking lot versus what you see in the street. And so that was a ground lease. They were able to do that with. Okay, so let's change that definition slightly. That's written in the book on page 248 for what the primary function of a property manager is. It's someone who preserves, right in there, or increases the value of an investment property while generating income as an agent for the owner. So years, that H Mart shopping center or festival shopping center was it was known as the H Mart because it was the only store there that was any significance. It was the biggest store that was there. Everything else was vacant, and there was only one strip mall, set way back in a big parking lot. Now that parking lot is mostly developed with stores all the way around it, and even 2 new buildings up front, all ground leases. Interesting, huh? Okay, so the property management agreement is a written agreement that creates the agency relationship between the owner and the property manager. It's their limited power of attorney that defines the scope of authority, how they can legally bind their clients to a contract. Most real estate agents function as special agents because you're very special, right? Remember that. But that means that you can't legally bind your clients to a contract because you didn't sign any kind of power of attorney or anything with them. Property managers work as general agents. They could legally bind their clients to a contract because they do sign a property um, power of attorney with the property owners. That power of attorney is the property management agreement itself. It specifies how they can legally define their clients to a contract and what scope of authority that the owner is granting to the property management company to do it, to what extent. So remember, property managers, general agents, and special agents, we're, we're all agents and we have the fiduciary duties we owe our clients. COLD, COALD, care, obedience, accounting, loyalty, and disclosure. So let's highlight that manager is usually considered a general agent, whereas most real estate brokers function as special agents. We all owe fiduciary duties to our clients, though. And we can be tasked with budgeting expenses, renting the property, maintaining and improving the property, maybe even evaluating the insurance that the property owner has on their property. Make sure they have proper coverages, not too much of this insurance, not enough of this insurance. As a property manager, we're not expected to be insurance experts, so we could get an insurance expert to come in and analyze it, though. Now, if you're a property manager, you should probably take one of those courses on property management to learn the ins and outs of how to do it, because it's got a lot of nuances, especially between commercial and residential property managers. If you're interested, NAR got a designation course, the CPM, Certified Property Manager. It was actually created by IREM, the Institute of Real Estate Management, in cooperation with BOMA, the Building Owner and Managers Association. There's another class you could take, or from an institute you could join, called CAI, the Community Association Institute. They teach people about managing condo complexes and such like that. Here's some resources I have on that. And here's about the CPM. That's been around since 1933. IREM was founded in 1933 as part of the National Association of Realtors, the Institute of Real Estate Managers or Management. And members may earn the designation of Certified Property Manager. You could also join BOMA. That's a federation and association of owners and managers that share information amongst each other on different ways to manage communities, to do improvements, softwares, to share legal issues and things like that with each other. So if you're interested in property management, it's a good idea to become a member of CAI as well. That was founded in 1974. And that concludes this chapter. Let's do the key terms to review for chapter 12. And let me pull up my thing here, opening for the next chapter. Chapter 12. All right, there are two key terms to review in this chapter. Let's start off with key terms 1. Landlord's responsibility for decent conditions.
Mm. Let me. Sorry.
So the landlord's responsibility for decent conditions, for providing decent conditions. When you rent from a landlord, it's expected that you're going to have a building that habitable and there are no conditions present that could cause a threat to the health or safety of those who are occupying the structure. So it is implied warranty of habitability. 9 is A. Transfer of property by lease.
Demise.
Yes, 4 is B. Situation where a tenant remains after the lease period has expired.
Holdover tenancy.
8 is C, holdover tenancy. A contract between the landlord and a tenant transferring the right to use the real property for a specific period of time in exchange for rent.
Periodic lease. Lease.
No, it's
Lease.
just yeah,
Contract between lease. Yeah.
yeah, it's just a lease. It's just a lease. 10 is D. A lease for a definite period of time.
Definite period is uh, period to period.
No, for
Estate for years. It's
a
fixed.
fixed term
Fixed.
has an end date in it. That's an
Mm.
estate for years. 5 is E. Suit for possession, legal
Actual
removal of a
eviction.
tenant.
Actual eviction.
Actual eviction, 1 is F. Rental of land on which a tenant erects their own building.
Ground lease.
7 is G. Tenant,
The C.
the lessee. 11 is H. Lease under which a landlord pays taxes, insurance, and other expenses.
Gross lease.
The gross lease. 6 is I. Transfer of primary responsibility for a lease to another party.
Assignment.
2 is J, correct. Tenant is forced to move because the rental unit is uninhabitable.
Mm, eviction. Constructive eviction.
Yes, 3 is 8. 3 is K, constructive eviction. All right, we'll do key terms 2, but before we do, next to letter B at the end of the line, you may want to write and not paying rent because that's an important factor. Tenants remaining after the lease term without the landlord's consent and not paying rent. That's what it should read.
Okay.
Then go down to letter D in key terms 2 and write automatically renews at the end of the line. And then after we have that, we can start. Okay. Lease, which the tenant pays expenses like property taxes, insurance, and so
Net.
forth.
Net
That's a
lease.
net lease. 3 is A. Tenant remaining after the lease term without the landlord's consent and
Sufferance.
not paying rent.
Tenant at sufferance. Tenancy at sufferance.
9 is B, tenancy at sufferance. A lease in which a landlord shares in the gross receipts of the tenant's business.
Percentage
Yes,
lease.
percentage lease. Correct. 4 is C. A lease with regular payments and no stated ending date. It automatically
Period.
renews.
Period to period. Periodic lease.
Periodic lease. 5 is D. Person who
Person.
looks after another's rental real estate.
Property manager.
6 is E. Tenancy that may be terminated when the landlord or tenant wishes.
Tenancy at will.
10 is F. Landlord's court action to evict the tenant.
Um, actual eviction.
That's not what they're looking for. That's not an option. It's also known as
Suit for possession.
suit for possession. 8 is G. A transfer of only a portion of the lease. It's a weird way of putting it.
Sublease.
Sublease, yes.
Mm.
7 is H. Property manager's employment agreement.
Property manager employment agreement. Management agreement.
It's the management agreement. 2 is I. State requirement that tenants be notified of their rights.
Truth in renting.
11 is J, truth in renting. Another word for landlord.
Lessor.
Lessors. One is K. And that concludes chapter 12. Next up, mortgages.
So